Have a seat.
I'm just going to be standing back up. I'm the one that's arguing this motion.
All right, have a seat.
I have a hard time getting up.
State of Arizona versus Lane Jeffrey Myers, CR 2025 1454. Hold on just a minute here.
This should be.
Yeah, 1454. Motion for media request. Parties' appearances will start with the state.
Rachel Stiles for the state.
William Parr, Mr. Myers. I don't know if the other case is also here where Mr. Myers represents himself.
No, we're only here on cameras in the courtroom for the 1454 case. So before I hear on the motion, I will note that I found that any personal audio recorders are obtrusive, distracting, and otherwise prohibited in this case, as with the earlier case. So I'm ordering that no personal audio recorders be used during this proceeding. Anyone who attempts to record this proceeding in the courtroom or otherwise be disruptive, I'll order the COs to remove that person from the courtroom. All right. We have a motion or request. From Mark Brown. Are you Mark Brown, sir?
Yes, sir.
Okay. Let's have Mr. Brown come up right over here in the corner where that microphone is. Then we could pick you up well. So you sit right there in the jury box in that corner.
Good morning, everyone. As Lane rots in a jail cell.
Yeah, you just have a seat right there. That microphone's hot, so you can we can hear you well. Okay.
Trust me, I will.
So, Mr. Brown, you've asked.
Yes, sir. Yes, Your Honor, I do.
All right. Why do you want to record these proceedings?
For transparency, and I got it. I've been doing this for 6 years now, and I got a ruling on that. I'm going to. Can I approach the bench?
Give it to my bailiff, and she'll give it to me.
Okay. See how many copies do I need here? So here's one for the judge, and here's one, two. Page 2. This happened in page 2 got missing, and I was trying to find it. By this number, you can look that up. This is Judge Gordon's ruling.
I have page 2 on here.
Okay, that at the bottom, that page 2 is a mix-up. If you look, that's the rules for. That's page 2 of the rules on 50-4 at the city court. So yeah, so that all that the page 2 is not part of this. That's my mistake.
Okay.
So stipulate. But if you go to this. It's December 26th of 2018, case C201. So if you go to there, you'll get page 2, but all the rest of it is accurate.
Okay.
It's just so you know. So anyway, and page 7 is the one that, page 7 is where, that's to this case. Just a little brief thing on it. I had injunction of harassment, just like him at city court, 3 of them, okay? The first one was I went to court and lost on justice court, and then it went to you. And you, the first one you ruled on, and you threw it out, not on the merits.
Me or somebody? I don't think that was my case.
Is there another Metcalf in this
No,
court?
no, only me. I don't recall that case.
In 2019, it's a long time ago.
Okay.
So it was 2018 or 19, right at the end of 18 or the.
Good morning, everyone. Welcome in. This is not live. This was yesterday's hearing, and this was before. I'm not sure exactly what time this happened, but this is Tucson Police Suck for a media hearing. So yeah.
Beginning of 2019. So I had 3 of them, and it's the same thing. It was public officials just about this case, and in that case, I appealed it because they said I had to get permission from the judge, like they are now on 122H. Well, when I was under the injunction, I had to follow all the rules. Well, 122H allowed me to tell the judge that I was going to audio record, and I didn't need permission. All I just had to do was notify him in advance. So I did that, and they said I couldn't do that. While I was under that injunction, I had to listen to their injunction. It says I couldn't do that. Then once I put the appeal in, argument number 2 on page 7, I'm going to read this real quick. So argument number 2 is on this case. Okay, Brown argues that the Pima County Justice Court misread rules 122 and 122.1, and they're still doing it. Okay, so reply, Brown argues that the Pima County Justice Court misread rules 122 and 122.1 to the extent that the Pima County Justice Court read the rules 122 and 122.1 to require Brown to get judicial permission before recording outside the courtroom in the courthouse, and to always get judicial permission before using a personal audio recording inside the courtroom. The court agrees with Brown, okay? And then it goes on to say, the injunction incorrectly states that Rule 122 requires Brown to secure judicial permission to film outside the courtroom and in the courthouse, and potentially overlooks 122H. And that's what I've been saying all along. 122H, I just have to notify you I'm going to be audio broadcasting even. Back then, I was just audio recording. I wasn't broadcasting. Then it goes on to say, the limit exception for this rule, the personal audio recorder in the courtroom, the court therefore will remand the case back to Pima County Justice Court so the injunction can be modified to reflect a correct or more clear reading. So it went back to the court, then they said I just had to notify. So when I was under the injunction, I was able to do that. And then they came out with these administrative orders that said everyone else couldn't. I could do it and everybody else couldn't because I had an order to, but everyone else should be able to because they have to read 122.
So, but in this case, are you acting as a member of the press, or are you just here on your? Okay.
I'm
so,
a member of the press. I'm
okay. So
Arizona United News.
That's a different rule that the normal 122 procedures apply.
But I'm doing it under I'm doing it under C, and then at the end of this on 122 it says under 122D it says denial or limit of coverage. A properly submitted request for coverage, and I put in a property request, should generally be approved, but the judge may deny or limit the request as provided in this paragraph. A judge's decision on the coverage request or objectivity to a coverage is reversible only by special action. I was going to do a special action, but as you know, I'm the one that put in. I went to the federal court. I filed it last week. I don't know if you got it yet, but that's me also. I'm trying to get my rights restored in the courtroom and to keep what happened in here before you came in. All these guys surrounded us. It made it hard for me to concentrate on what I was trying to do because all these guys surrounded me and telling me to do something.
I told the officers that you could not record until we had the hearing.
Yes, and I'm not recording.
Okay.
And I also got this order from you that says I can't, you put that order on me and it says I can't. So that's why I'm not. Last time I was here, they wouldn't let me in the courthouse. They made me surrender their phones to them to enter the courthouse, and that's prior restraint.
Hold on. No one's doing a prior restraint. That's when you can't say what you want to say. No one's ordering that. The courtroom itself is open, and you can sit here if you behave and listen. The question is whether you can record either audio or visual. That's not a prior restraint.
Well, I can't, like I said, by the rule you just read, 122H allows me just to notify you. But if he makes everyone turn their phones off, everyone that wants to do 122H can't. All they have to do is notify you or your staff, And when I was going through this, they gave me these blown up rules. Dick Tracy and Anna Meadows and they gave me all these blown up things. And I said, great, can you guys read it and follow it? Because them guys can't make everybody turn their phone off when you're.
Hold on. I have control over the courtroom, and I can order things to make sure that
Not
the
all
proceedings
things, though.
happen respectfully and quietly and with dignity. And if there are people here in the courtroom causing a disruption with recording, that.
I want to just, I'm going to be interrupting this whole thing, so if you want to hear this, go wherever, go to Reluctant Prophets and listen to it there. I think he broadcast the whole thing yesterday. Can somebody explain that one to me? I wish I had uploaded this to YouTube so I could go back on the time a little bit.
Make sure that the proceedings happen respectfully and quietly and with dignity. And if there are people here in the courtroom causing a disruption with recording.
How does one cause a disruption by recording? It's not expressive. How does one cause a disruption recording? Now, I'm sure people can be disruptive while they're recording, right? Just like I think that people can be disruptive without recording. I don't know. It's a real tough one. How is it that silently recording is disruptive? Chat, you guys got any insight?
That is not consistent with that. And so I have the absolute authority to deny anyone the right to record anything.
But
Absolute right to deny. You would think except as provided under 122H. Personal audio recorders. Required notice to the court. A person may use a personal audio recorder during a proceeding, but the person must notify the judge. Must notify the judge or the judge's staff prior to using the device. Must notify the judge. Okay. A person who uses a personal audio recorder is not required to submit a request under paragraph C of this rule. But a person who wishes to record or broadcast the audio portion of the proceeding with a device that is not on the person must do so. Okay. The use of personal audio recorder must not be obtrusive, distracting, or otherwise prohibited. So he says recording is obstructive, distracting, and he says he can prohibit it. But the rule says otherwise. Metcalf says that the act of recording is obtrusive, distracting, and prohibited. But the Supreme Court says, well, we see what the Supreme Court says. They say something other than what Metcalf is saying.
no one was making it. No, we just sitting here.
There's been a lot of chaos involved in this case.
Yes.
Unusual amounts.
From the prosecution, I got it, but
No,
it
not
wasn't
from
me.
the prosecution.
Warren, look who's here, everybody. Hey, Warren, what are you talking about? Did Lane get charged for recording his court hearing after the judge made it clear not to? Well, if Lane recorded a court hearing, he did so under 122H. So if the judge told him not to, he didn't need to listen to that because that was nonsense. But I don't even know what Warren's talking about. What are you talking about, Warren? Warren. Come on, Warren, tell us.
It wasn't me.
It's-
The problems never was me. It never was, and that's the problem.
Well, why do you want to record it?
Yeah, that's it, and that's exactly it, Liberty Troll. I don't know why the judge thinks this. Maybe he's seen it before or something that that it becomes, what were the words again? Obtrusive, distracting. Obtrusive and distracting. So I'm gonna go with the distracting since he said it. Let's rewind.
Causing a disruption with recording, that is not consistent with that. And so I have the absolute authority to deny anyone the right.
Okay, well, causing a disruption wouldn't be consistent with that, right? But silently recording, silently broadcasting would. So it's not looking good for the judge not understanding the rules. Why doesn't the judge understand the rules? Why on... Is anybody else concerned that he's the guy in charge and he doesn't even know the rules? So we can depend on him to know the law, right?
To record anything.
But I wasn't, no one was making it, no, we were just sitting here.
There's been a lot of chaos involved in this case.
Yes.
Unusual amounts.
From the prosecution, I got it, but it
Not
wasn't
from
me.
the prosecution.
Not from the prosecution? What? Is he serious? From the prosecution, for sure. For sure. From the Pima County prosecutor, from the Tucson City prosecutor, from the University of Arizona. I'm going to start doing the Rachel laugh.
It wasn't me. The problems never was me. You know, it never was, and that's the problem.
He's making a good point, right? Just because somebody did something sometime, somewhere, and he witnessed it. But I haven't seen chaos around the recording, around 122H. The first hearing, I'm not sure... It must have been after arraignment, but he gave notice, Lane gave notice, and then they discussed it. And then the judge said, okay, you're not going to do that. But we have no record of that hearing, right? Because actually it wasn't that hearing. It was the next hearing where they said, okay, we're going to set up a hearing to talk about the recording. So they set up a hearing to talk about the recording that they didn't record. But that's not a problem. I mean, I'm grateful that this is being streamed, right? I think that, okay, this complies with 122H, right? But I don't see why any other person that wants to go in there and do audio only. Now I realize that his argument is changing here and it's going from 122H to 122C, and the judge does have discretion over that, right? The judge can deny that. You know, you might want the video, but we can see that, you know, in secret courts things happen differently sometimes.
Why do you want to record it?
I want to record for transparency because last time when Anna Meadows told me that morning on that last hearing, because you approved it the day before.
Warren, no, he didn't get charged with anything because it's not a crime. But go make sure you go send everybody an email and let them know. Go tattle, Warren. Go let go let everybody know. Go let everybody know they didn't charge him with that one. Oh my God, it's an ace up their sleeve. He recorded the court hearing. He recorded the court hearing. Let's put him in solitary confinement for that one. No food, solitary confinement. He recorded the hearing. He wanted the public hearing to be public. to the gulag.
I thought, great, a judge that was really standing up for us, and then I could sit at home and watch it on my TV. I'd rather be at home. If you would have put it up like you said you was going to put the audio and video up there, then you came on the 15th, I think it was, and then reneged on it. So I was at home. I was going to rush here, but I couldn't get here in time, and I wanted to see. Everything. And when I was listening to it on the audio, you kept saying to Lane Myers that he was being threatening you because of the way he was looking at you. Well, I wasn't here to see that. I wish I was in there to see if that was happening because you can't see that over the audio. And then that's why I would like to be here, and I'd like the audio and video record. And the other courts always let me. Like the city court lets me do just the judge. I put my gimbal up here and put it just on the judge. He won't, and then the other places on this court, they let me record anywhere. And Justice Court, I've did it several times. I do my own case. I've did it dozens of times. This is the only time someone ever told me I couldn't do 122H since I had this injunction and before I appealed it. But before then, I couldn't do 122H.
Okay.
But I should be able to walk into the courtroom and tell your staff that I'm going to be audio broadcasting. I know I can't turn it on until you're on the bench because it says in there that you can't do it when the judge is on the bench. I've been going over 122.1 for 6 years. I've been in jail 4 times for it, and I've never been convicted of it, but I've been harassed by security, especially Dick Tracy and Mary Jane. I was in an arm cast for a month and a half because of Mary Jane, what she did to me in Justice Court. And in Justice Court's even different because they got common areas that you don't have to go through security. You can go to the treasurer. You don't have to follow 122. In the rules of 122 in the courthouse, it says that when a courthouse is used for other things like Justice Court is. But I still was attacked by the security from this court. They come over there too, Mary Jane and Dick Tracy both. And I'm just trying to get my rights to record so I can find out what's happening here, and I don't got to rely on somebody else telling me that was sitting here. Their memory. My memory's bad. I like to go home at night, and I can't hear very good. I'm a disabled veteran with hearing problems. I like to go home at night, turn my stereo up, and listen and watch. And watch it. I like to see the body. I would have liked to seen what Lane Myers was doing to you, staring you down or whatever. I would have liked to see that to see if that was true because I didn't hear any threats. And you kept saying that he was threatening you. And I didn't hear it, but then you went on to say that he's looking you down and he's doing other things. I would just like to be here to witness that. And if you would,
Well, you can be in the courtroom to witness it.
Yes, I know. But what I'm saying is I was going to do it from home because you said that you was going to.
We all want to see Metcalf. You've made some wild accusations, and you're going to say some fucking crazy shit today. You are going to say some insane shit today. But what?
Broadcast the audio and video. And if you would do that, I wouldn't have a problem here. I would go home right now if you broadcast this one at 3 o'clock to everybody. And the 2 people you denied, the Phoenix Times and RP, let them do it too. If they have the link, they should be able to do it. And anyone should.
Clifford, that's exactly right. You walk in, you say to the clerk, I'm going to be recording or broadcasting under 122H. Or when the judge comes in, you say, Your Honor, I'm going to be recording or broadcasting under 122H, and then that's it. As long as you do that silently and you don't have this giant gear with like a boom mic, that might be obtrusive. Or you're waving your arms around and doing crazy shit that normal people don't do. Then you might be distracting. Huh. Okay.
Be able to watch it live. And if they would do that, I wouldn't have no problem. Transparency is my main issue.
Okay.
I want to be transparent. I don't want to have to drive down here and pay your parking meters and go out there every 2 hours and feed the meter.
Okay.
I would rather sit at home and watch it. So if you was to say that you're going to broadcast the one at 3 o'clock, I'll go home, we'll forget about this, and then Phoenix Times can do it. RP can do it. Anyone else? They don't even have to be here to watch it. Then we can all sit at home and there won't be look at all the money and the security that's costing because I'm just trying to exercise my First Amendment right as a press.
Okay,
Freedom of the press.
let's hear from the parties.
Can I say something, Your Honor?
No, let's start with the state.
Your Honor, this court has been live streaming the proceedings, that it does provide the audio to anybody who wants to listen in. So that's been available. The courtroom is open to the public, so anybody who wants to see it, they're able to come into the courtroom. 122H only allows personal audio recorders, which is a device used to record audio only. The problem is they're using cell phones. Cell phones are devices that can record much more than just audio. And so they're not the typical audio recording device. If they were holding a handheld recorder, that would be a different device, but that's not what they're coming in.
Is this bitch really that stupid? Just because something does more than one thing, you can't use it? Jesus, bro.
With they have the device that is capable of filming, and that's really hard for court security, court staff to monitor to make sure that there's no
Maybe they don't monitor it. Maybe they just they make the announcement, you can't video record, and if somebody video records, then you deal with it, right? Then you don't take away everybody's rights because one time, sometime, somewhere, somebody did it. Rachel.
recording done of the people in this case. This is a harassment case.
She's right about that. It's a harassment case. They are harassing the hell out of Lane Myers. They're harassing the hell out of Lane's significant other. They're harassing the hell out of anybody that speaks up and tries to do the right thing, which is stand up for an innocent person. Okay, Rachel. Cool story.
Everybody in this case involved, the parties, so it'd be the victim in this case, the court.
Today it's just a victim. Today she's narrowed it from victims to victim.
Attorneys have all been subjected to being put on YouTube and broadcast. We have the live streaming, so it's open.
Yes. You're all public officials. You're all state actors. You all work. You're supposed to work for the people, right? You're supposed to experience some public scrutiny. And when you do what you're doing, Rachel, do you expect not to be scrutinized? That must be it. You expect not to be scrutinized. You expect to be able to do whatever you want with impunity. I mean, what else are we supposed to think? Chat, you guys got any answers? What else are we supposed to think? He sits in a jail. She is dead set on making sure that Lane doesn't have bond over some YouTube videos. And she thinks she's not gonna go down like April Sponsel. You've lost your mind, woman.
Open to the public so everybody can hear about it and they can come here in person. There's no reason for them to be able to audio record it separately from that, and there's no reason at this point to be filming anything that needs to be broadcast. And so to try to maintain the integrity of this case, I think it is important to not have...
Maintain the integrity of this case. Maintain the integrity of the case. She is serious.
Them coming in with their cell phones and video recording it so that it can be broadcast, because that's leading to further harassment in this case.
Okay, Mr. Parvin?
Yes, Your Honor. Real briefly, the reason I wanted to go first is I understand you have a contested hearing right now. We will be prejudiced if we don't get our hearing as well today, and that's why, for that reason alone, can we handle this another day and just proceed so we get our hearing today? That's the important part, Your Honor, is that you can get the hearing scheduled.
We're here, hold on, we're here on the, Mr. Brown's request to film these proceedings.
I'm just saying our position is that you need to get to your other case that was scheduled that's important, so we get our fair hearing at 3. My concern is if we go any longer here, there won't be time for our hearing at 3.
All right.
And what happened? There wasn't time for the hearing at 3. They ran out of time, right? Well, we'll see. We'll see. And, you know, it was just no big deal. It was no big deal. And what is it, May 5th? That's the next hearing? But there's no prejudice, right? There's no prejudice here. How many days is that? That's another 2 weeks. Without any access to legal resources, right? They start talking about the issue at the end, and they say, "Oh, we'll come back in 2 weeks and talk about this." Well, in the meantime, what the hell is he supposed to do in the meantime to aid in his own defense? He's the attorney of record on the original charges. But I mean, it's only another 14 days. His speedy trial, there's no prejudice there, right? Another 15 days of time gone where he basically can't do anything other than rot.
Mr. Brown, I'm going to deny your request in this case. The courtroom itself is open to the public. Anyone who can follow the rules of decorum can sit and watch.
So anybody that follows the rules of decorum can sit and watch. But if people are not obstructive or distracting, they still can't record. Make that make sense.
That happens. We also live stream over our YouTube channel that was made available to us during the pandemic, and which I've continued to use. I'm a big believer in allowing transparency, but there is too much. It's too disruptive in this case by the number of people who've been wanting to come in to record.
That's why the original media request was made. Metcalf, right? And there could have been one person in there, like the news. It was a media request, and that one person would have recorded silently. And then all the people, everybody would have had access to that video. That becomes public video at that point, because there's one media company allowed to be in the courtroom. So, therefore, that media is available to all of the public. Just like if he had broadcast the video on the YouTube channel, it's available to all of the public.
We can't have staff constantly looking at everyone's cell phone to make sure that they're following the rules. Typically, when we have a reporter who wants to record, they are very reliable, follow the court orders. And as I said before, there's a certain level of chaos that's happened in this case, and I'm trying to tamp that down. It's hard to follow.
Sounds like prejudice.
To make sure everyone's following the rules. So I'm making a finding that use of personal auto recorders would be obtrusive, distracting, and therefore I'm ordering no personal auto recorders in this case. And I'm denying also the request for cameras in the courtroom for the following reason. I'm concerned about the impact on the victims who have been at a lot of these hearings, and whether they would be videotaped sitting in the gallery, which I would not allow. And again, it's hard for us to watch everything all the time. That's the main reason. I just think it's really
But they also want us to expect. They also expect us to believe that there's not a hell of a lot more security dedicated to this specific case in the courtroom. Okay. All right.
Hard, and it affected the proceedings here, and for us to have, we have 1, 2, 3, 4, 5. We have 6 COs in here to make sure that this is running well.
6 COs. You got to be fucking kidding me. They got 6 COs in there, but nobody can. I mean, they must be in an enormous courtroom. 6 COs. What the fuck? Okay. All right, Metcalf. But there's a certain amount of there's a certain amount of circus going on, huh? But it's Mr. Myers must be doing it from jail. It's not the circus that comes in every time there's a hearing for no reason. The guy that's never been violent, ever, with anybody. I'm still waiting for people to send me the video clip where he's telling people to harass and telling people to be violent. I'm still waiting for that clip to come to my email. But we all know it's never going to come because it doesn't exist.
So we can't do that in every courtroom all the time. So that request is denied. So I'm ordering, consistent with the other case, that the request for audio or video recording or a personal audio device is denied. Further ordering that no audio or video recording devices or personal audio recorders will be allowed in the courtroom or outside the courtroom within the courthouse for any hearings in this matter. And I will notify court security. So, Mr. Brown, I appreciate your arguments. Obviously, you have the right to file special action with the Court of Appeals if you don't like my ruling, and I think the rule provides for special action jurisdiction. And I don't know if you know how to do a special action or not, but that's filed with the Court of Appeals.
We looked into that, but I just went to federal court.
Okay.
I already filed it.
Okay,
You
that's
should have
great.
got it by now. But,
Exactly, Clifford.
But there are other, can I say one thing?
They're there to make
So,
sure that people
the
don't
other thing
follow
is,
the
if you
rules.
was to do like he was saying, audio broadcast it from audio and video from your thing, all the problems you mentioned would be gone. Every one of them would be gone if you just if you would audio broadcast just like they did at this original hearing.
I am auto broadcasting.
Audio and video broadcast, just
well,
like they did at this original hearing in this courthouse when they did this to him. They was doing both.
There's not an appeal process. There's a special action process where I don't know if you can file a special action without incurring. I think it's like $400 or $450. I'm not an attorney. I'm certainly not an Arizona attorney. So I don't know I don't know if that's actually the case, but no, there's not an appeal process where you can do that without incurring further cost.
I sat at home and watched that.
Okay.
So I know you guys got the equipment to do that. So if you would do that, that would alleviate all my problems, and I could sit at home and not have to be here if I could watch it audio and video. So I just ask that you audio and video it, and then I'll be okay with it. And that'll do away with all the problems that you just said. No one will be out here. You won't have to have 6 COs in here. And then we'll all be happy. So if you could do that for me, I'd be very happy.
Yeah, I'm going to deny that request, but I appreciate you making the argument. With that, we're adjourned in your excuse. We'll take a break, and then we'll come back, in this case, at 3 o'clock.
Lawsuit stands.
So, Grande, that's not entirely true.
Staples, you have this? You don't want this? Sure.
I mean, it was a court order, but it was the bond order that, I mean, he's on no bond for allegedly committing a felony while on felony release. That's the trick up Rachel's sleeve that she got. Let's charge the guy with a bunch of felonies, and then when he makes another YouTube video, we'll charge him with another felony. I think they would have done this either way. You know, they would have. It might not have fit into the timeline, but I still think they would have tried some Weasley shit, because that's, come on, are we being real? That's what they've done the whole time. They're dirty, nasty weasels. All right, so there's a hearing in between these two hearings. Let me just tee up the motion hearing, and it was supposed to be. I think it was supposed to be more pretrial stuff. I'm not positive about that.
Trailer. You know what I mean? So
Okay. And, you know, the clothing is listed that, you know, that was left there at the scene is $7,000. Is that an accurate statement amount of how much your clothing was worth?
I don't know.
Wages?
And you indicated to the court that you're able to work now, at least in certain jobs?
Yes.
With respect to the medical,
As far as what? Unfortunately, I don't necessarily have an answer, and I don't know if defense might have a suggestion.
His actions as a specific person, including contacting her on the phone, I think is in the 1454 matter that Mr.
But you're hearing on that or not, underneath there's any disputed facts.
Well,
Not so
so just a minute here.
depending on what's,
Yeah, their version of the facts.
I know, that's dependent or not.
But we can hash that out. Right?
Try. But you're hearing on that.
Because we joined.
All right, I think we got it.
There are a bunch of motions.
Victim is present.
They're definitely flexing on. That's definitely what they're doing. I mean, this is the punishment phase for sure. They want the punishment phase to last his
All
entire
right, let's go on the record
life,
in the matter of
but
State of
this
Arizona
is-
versus Lane
it's
Jeffrey
already
Myers,
begun.
CR 20251060, a pretrial conference and a hearing on pending motions, and then, well, let's do the appearances on that case first.
Rachel Stiles for the
You're
state,
still here,
Your Honor, the
Lenny.
victim is present.
Okay?
Is this the, okay, this is 106, which one is
Yeah, the
this?
first case.
Lane Myers for myself.
Okay.
Thank you.
All right, and then in the second case,
It sounds like it's his first case. He already doesn't understand 122H, so it's like he hasn't even read the rules. I guess we're going to find out if he was like Slammin' Sammy and got his law degree out of the Cracker Jack box.
CR 20251450, status conference regarding trial date and pending motions, parties' appearances in that case.
Rachel Stiles for the state, and the victim is present.
William Harvey, Mr. Myers, he is present in custody.
Okay, there are a bunch of motions pending.
Yes, and we're actually here for one of them today on the request for a bond rehearing. So that one we actually did have this time set for.
Okay, well, you want to address the other ones or not?
Well, yes, we'll just have to set, I think we'll just be setting dates on them, but yes.
Unless he wants to hear them. I want to.
Well, I mean, I think we have 2 hours here.
Okay.
Let's do it.
Yeah. So let's,
I just filed my reply like, an hour ago.
got it.
Okay, thank you.
all right. So,
They have 2 hours, but he's going to make sure that he cuts him short just at the end when he's trying to get that law library access. Got to cut it short for some reason. We got 2 hours, but fuck it.
first of all, and this is in case 2025-1454 as to the defendant's motion to exceed the page limits or extend the page limits.
That was
I
for
didn't
1060. That's my, because we joined orally.
Oh, I'm sorry. Yeah, I had it backwards. CR 2025 let me write it on here. 2025 1060. The motion to exceed page limit is granted, and that motion, I think it was a reply brief, Mr. Myers.
Reply to the response, yes.
Yes,
Yeah,
so we
got that.
both
Okay.
submitted a reply.
What's that?
I submitted a reply on my end, and Mr. Meyer submitted his own reply.
Okay.
For the 2 separate case numbers.
All right. So then, and that had to do with the motion to dismiss
Vagueness, overbroad.
overbroad. Okay.
That's the only one I wasn't sure if we need an evidence, but you're hearing on that or not, on any, if there's any disputed facts.
Well,
Not so
So just a minute here.
depending on what's,
yeah, their version of the facts.
I know, that's dependent.
But we can hash.
Well, that's the thing about no contact, right? Because he didn't have contact. I mean, there was no contact. There certainly wasn't unlawful contact. I think that there actually might have been an email, a notice email on, I can't remember, actually. So I shouldn't speak with such certitude, but it was something that if he sent an email, it was a requirement, of notice. I'm not sure if it was in the civil cases or the appeal on the injunction. And, he's in the gulag to ask, so.
Try, we'll see. Don't want to have too many things going at once, so we don't know exactly what we're doing.
Not for you.
No, they did. No, James, it's not that they got him for driving by the courthouse. They already got him for driving by the courthouse, right? And he already beat that. This time they got him for making a video about driving by the courthouse. And that I'm pretty sure that's a felony. To these sick, twisted fucks.
Okay. So the motion to
Thank you,
dismiss
JC.
aggravated harassment counts on grounds of vagueness, overbreadth, and First Amendment is in the 1454 matter that Mr. Parvin filed. I read the response and the reply. And then, Mr. Myers, you joined in that, I take
joined in
it.
at the last hearing where you were absent.
Okay,
Yes, and then so I filed my own reply to their response.
okay. So what I'd like to do to keep things, well, I'm going to start with Mr. Parvin making the argument, and then I want to hear from Ms. Stiles. And then I don't know that there's anything that you would add to that in the other case that would be unique to.
He started it, you know what I mean?
But I guess what I'm saying is in the second case where in the first case where you're representing yourself, I don't know that that there are any facts that are different than the first case.
Different counts.
Different counts, but
the same harassment, yeah.
the same legal argument, right? Okay.
Most correct.
All right,
Different
so,
set of facts, 'cause-
Mr. Parvin, I'm going to start with you, and before I turn it over to you, I did review the statute 13-2921, which the legislature did amend in 2022 to remove the intent to harass with knowingly harass, basically.
Right, but even that's a problem, as I mentioned in my reply.
Right. So I just want to tell you that I did have a chance to review that and the legislative history, which was not particularly illuminating. And of course, I reviewed the State v. Brown case, the 2004 case I had cited previously. So, Mr. Parvin, go ahead on that argument.
Yes, Your Honor, I think it's very clear that the legislature realizes they made a mistake. That's why they're in the process of changing it back to intent. They know that they accidentally changed it to an unconstitutional statute. You know, State v. Brown very clearly says you need to have intent in order to make it constitutional, where it takes speech out of the First Amendment. That's very clear in the case law, Your Honor. That's the only reason why it was upheld. And that's been cited in every case since then. And as I mentioned in my motion, this court has the opportunity, a rare opportunity, to be the very first court to address this issue, because there is no case law on this current statute, as in this. Either way, it likely will go to the highest of courts because there is no case law on it. But again, I think the biggest support of our argument is the legislature knows they messed up. That's why they're changing it back to add intent. And if you look,
But let me. The Brown case says criminal liability under the statute is based on the manner in which certain communication is conveyed and the underlying purpose for the communication. So they're saying that's why it's constitutional. They said this is made clear because they're specific to intent to harass.
correct.
It doesn't say you have to have specific to intent to harass. How is knowingly harassing different than intentionally harassing?
Well, if you read my reply, Your Honor, I've explained that. The problem, the legislature is aware of it, is that it doesn't require to knowingly know about harassment. It only requires you to knowingly act. And that's why I gave the court two examples in my reply where you can knowingly make an act. If you look in my reply, the first example is you want to criticize your government or starting to get laws being passed. You encourage contacts and call your senator, call your mayor, call whoever. You're knowingly acting. You're knowingly making this YouTube video or social media. And so you've already met that requirement. You know exactly what you're doing. But then, according to the current unconstitutional law, there's no back end. As at that point, if harassment occurs, or if they think harassment occurs, the prosecutor does, or the other side, then you're guilty, sadly. And that, if you look at counterman, that was the problem the United States Supreme Court held. It's the exact same phrasing, manner that. And that's why the legislature, I think they picked up on this, said, oh, we got a real problem. We need to change it because it can't be a manner that. It's got to be with intent. So the United States Supreme Court very clearly prohibited the language in this current statute, Your Honor, when you don't have the mens rea in the front and the back end, if that makes sense. If you read my reply where I've illustrated why that even with the knowing, there's no knowledge of harassment. It's only the knowing that you're committing an act. And
But let me see. The statute says a person commits harassment if the person knowingly and repeatedly commits an act or acts that harass. So doesn't the person have to know that they're knowingly harassing the alleged victim?
see, that's where I think the statute's vague, and I've outlined all the other definitions, which is the problem. It's not clear to when you are or not committing a crime here, Your Honor. And I think, again, I'd like the court to review the counterman decision by United States Supreme Court where it prohibits that language. It actually, so you can't just say a manner that. And that was the problem that the United States Supreme Court had. And again, the concern is, what is it knowing? Is it knowing, very clear you can know you're making an act, you've acted, but it doesn't differentiate knowing also that the consequences of that action for harassment. And again, that's why I illustrated two specific examples of where you could have knowledge and you'd still be unconstitutionally basically punished for exercising your First Amendment. The other problem is it's not just about the knowing act. It's that there's no way to use social media here. That's clearly a violation of the First Amendment because that's not protected under this current statute. It is under the other statutes, and that's why I outlined the other definitions, but not in this one. This one, it has to be in-person protest, a very specific three only things you can do. Other than that, you could be found guilty. So that does regulate conduct, Your Honor, or regulate speech against the First Amendment, which means you cannot use First Media or you can't be charged. And that's why on the other statutes, the legislature is aware of that. They made sure that's not a problem. But they messed up here. They forgot this one statute that needs to be fixed, and they are fixing it, Your Honor. It's in the process. But as currently written, I think I've outlined it very clearly with examples and all the reasons why it's a problem. It's vague and overbroad, Your Honor. And Mr. Myers is harmed because he doesn't even get his chance to argue to a jury he had a legitimate purpose. He's not permitted to, and that's a real problem.
So the statute, again, as to the definition of harassment, and the criminal definition is a little different than the injunction against harassment statute, correct?
Yeah, and that's a problem of its own because you're told to follow one law, and then yet you're criminalizing another. And I think I outlined that as well in my problems with the definitions of why it's vague.
So in this case, again, they're just allegations. There's been no findings yet, but the allegations are that he directed his actions as a specific person, including contacting her on the phone, I think driving to her office, videotaping her office, which is more than just speech, it's conduct. So that's conduct that's directed at this alleged victim specifically.
And as I'm trying to outline, the problem is you're taking the jury out of it, Your Honor, because the statute does not permit us to refute that at trial. As in, we disagreed there. That would be a trial issue of what really happened. But the problem is we're not permitted to argue legitimate purpose at trial. We can't. The law does not permit us that defense, and that's what makes this unconstitutional. And Mr. Myers can't go and claim he used social media as a defense because that's not permitted either. This statute very clearly only lists 3 ways you can defend yourself, and I think it's picketing, in-person protest. I can't remember the third, but there were only 3. I know social media was not one of them, and it's not up to date. The legislature's aware of that. That's why they're fixing it. If you read the other statutes, it lists all protected constitutionality as a defense, and it says that you must have no legitimate purpose to be found guilty or liable. Even the civil injunction statute requires there be no legitimate purpose. Now, if the court wants to go into the prior hearing, I want the court to know that was a civil proceeding with a lower standard, and Mr. Myers was not represented. He's not entitled to an attorney in a civil case. So, I mean, honestly, I personally think, well, I don't know for sure, but I think a competent attorney might have won that hearing if he were represented at that civil hearing. So I don't think it's fair for this court to use that particular ruling or proceeding against Mr. Myers because he wasn't represented and it's a different court. And I think it could have went very differently with the right attorney arguing the law, if that makes sense.
And she lied through
her teeth. It's also under appeal. But my point is, for this case...
As to that point, though, when there's a valid court order, you have to follow it, even if it's later overturned on appeal. You understand that, the difference? You can't say that we didn't really like the ruling, therefore we don't have to follow it.
Yes, and I only bring that up to show why I don't think it'd be fair to take that ruling and say, oh, there's no legitimate purpose, as in there wasn't an attorney involved, they didn't prepare a proper defense with an attorney. That's not the issue. The question is the whole statute itself, not all the harassment statutes. As I've noted, the electronic harassment, perfectly valid and constitutional. The stalking statute, again, constitutional. We didn't ask to dismiss that on this basis because it allows a defense for social media and all protected activity. It allows you to argue that you had a legitimate purpose to a jury. Same with the electronic statute, and even the civil one, although that's not an issue at this trial, allows those defenses. The problem is the one at issue, which is both the misdemeanor harassment and the aggravated. Again, the fact that there was an injunction in place and made it aggravated is not relevant for this argument.
Right. What I understand is you harass plus there's an order in place.
Right.
But the harassment's still the same definition.
Correct. So that's not the issue. The problem is this particular definition is unconstitutional. This particular charge is unconstitutional. And the legislature is very aware of this problem. They are changing it back to put intent back into the statute. They're going to follow counterman. Again, I asked the court to review counterman. The same exact phrasing that was prohibited in counterman is in this statute.
Okay. Mr. Myers, just very briefly, I think your lawyer and the new cases argue the issue well, but anything you want to add as to the first case where you were?
I want to say something about the point you're making about knowing, direct conduct directed. Well, there are people you're allowed to direct conduct and speech at. It's called public employees with a loyalty oath, like Shannon Walker. She has a loyalty oath to uphold the Constitution. You can direct conduct and speech at politicians. You can direct conduct and speech at you. There are people you're allowed to direct conduct and speech at. that the law does not provide an exception for, because you can't say it was constitutionally protected. And that's why the new law is going to say you're allowed to direct conduct and speech at public officials to criticize them.
Slow down. Remember, we have a court reporter.
My bad.
Okay.
So like the whole, it's your whole, oh, there's conduct and speech. Yeah, there are people that you're allowed to direct conduct and speech at legally. But that's the problem with the current law is I can't say, oh, well, yeah, I directed conduct in that speech at that public employee in the course of their public duties and I criticized them. That's why the new law is going to add that in also. That's what the problem is you're making it seem like you can never direct conduct. And I didn't direct conduct, but that's a different thing. But the point is that the law doesn't say, oh, well, except for the people you can direct conduct and speech
So,
at.
Mr. Meyer, let me ask you a question. Let's say that you don't like your property tax assessment and you want to contact the assessor's office. What if you continually called them auto dial all day long so that all their phones were blocked up?
Yeah, that's been ruled.
Is this guy serious? This is the judge that, we want to keep everything. A few minutes ago, he didn't know the rules. Okay? Now we're talking about that oath, right? That oath that he swore to defend. And he doesn't know, if you're not happy with your property taxes, that you can call all day and complain about your property taxes. No, does anybody else see a problem with that? I see a big problem with that the judge doesn't know that if you're not happy about your property taxes, you can call up and complain about your property taxes if you wanted to. You could even go down to the assessor's office and you could complain in person. Right? And if everybody was all hidden away and hiding from you like they like to do in those public offices, if you happen to encounter a janitor in the hallway, you could talk to that janitor and you could say, man, I'm here to complain about my property taxes. My property taxes are really too high, Mr. Janitor. And you know what? The janitor can't charge you with harassment for complaining about your property taxes.
You think that you can do that?
Yes, that's been ruled on. They have to just put your number to it. They've already ruled social media and all that. So listen, this has been clearly litigated through courts all over the United States. You can call every day, all day, and all they can do, they can't even block your number. They just have to send it. And I know for a fact that that's happened here because I've called and tried to do stuff, not repeatedly on auto dial. I don't even know what that.
Has anybody else encountered this? I've called Pima County government, and I've been rerouted to the nuisance line, to the nuisance voicemail. Doesn't he actually have an email? Doesn't he have email proof of that this is what they're doing? Getting sent to the nuisance voicemail? But the judge doesn't know that you can call your local government and complain. And we're supposed to depend on him to protect our rights. And we're supposed to trust his understanding of the law while Lane sits in jail when he clearly knows the law better than the judge. It's the First Amendment, Judge. Are you serious? You wonder why there's a tension around this, Judge?
But the public employees cannot block your communications. They can send them to. They can I could email Shannon Walker 500 times a day, and all she could do is send it to a spam. She cannot block me from contacting, and that's been ruled on all the way from the lowest courts to the highest court, Supreme Court. And your example is a perfectly reason why the statute is overbroad, because you just gave an example of perfectly legal behavior that you're questioning whether that's legal or not. Well, that's clearly been litigated all through the courts. There's people that call their politician from the time they wake up to the time they go to sleep because.
How do you tell the judge he's an idiot in open court without telling the judge he's an idiot in open court?
They can't. The people can't block their communication. You can't charge them for it. You can just send it to a number that rings. I mean, I know for a fact I'm on that number at the Pima County Attorney's Office. You know, they send my stuff to send my calls to, you know, some dead voicemail that just, oh yeah. And this has been litigated many times. Twitter, you can tweet at them. The point of the law is supposed to make an exception for First Amendment protected activity. Otherwise, you're saying that you could contact a politician and get in trouble. You can't, though, because it's clearly First Amendment protected activity, and that's why they're changing it, because this is such a gray area that I have 486 videos criticizing public officials, calling them repeatedly, calling them again. But just so happens I'm only charged for one of those people, including 10 judges in this court. I've called their JA all day. Hey, you know, I literally have called Judge Liskey's JA 50 times and talked to her. And she said, you know, hey, and then she answers, talks to me. You can't regulate First Amendment activity by calling it harassment, and that's what this is doing here. Yeah, I know I'm contacting a politician. I know I'm exercising my First Amendment right. You can't say that it's harassment because you have a loyalty oath that says, I solemnly swear that I will support the Constitution of the United States and the Constitution and laws of the state of Arizona, that I will bear true faith and allegiance to the same and defend them against all enemies, foreign and domestic, and that I will faithfully and impartially discharge the duties of the office.
Slow down, Mr. Meyer. Remember,
You're doing fine.
Of the Board of Regents. That's what Shannon Walker is. According to the best of my ability. And so therefore, right there, you're saying that because I took this loyalty oath, I'm allowed to be contacted with manner, you know, speech and conduct that is constitutionally protected. And it's clear that that's why they have a loyalty oath, and that's why I haven't been charged for any other ones. We could put Rich Tracy up right now. I got more videos about him than Shannon Walker. He would love to put charges on about 50 people who have hundreds of videos out about him, right? No, he can't, because he knows he took the loyalty oath, and you know, he can come up right now and go under oath and testify that he's had to tell multiple employees at Justice Court and at Superior Court, hey, it's his right to call as long as he doesn't threaten you, true threats. And I also have an order from a federal judge saying the same thing. As long as it's not threats, true threats that are not protected by the First Amendment, I can call from the time they open to the time they close. I've called Judge Zips 50 times in one day. I've never been charged. It's not harassment. It's not a crime to call your local politician 100 times a day.
All right.
It's literally not.
May I add to this?
Sure.
I also want to just clarify that we're not asking this court to rule on whether you agree.
But before he clarifies, the fact that the judge doesn't know that should be chilling to everybody. I know that it's sadly apparently the norm. I wonder if him and the Dabbler hang out.
That Mr. Meyer's conduct was correct. Our issue is the statute's unconstitutional because we don't even get a chance. We can't even go to a jury. That's what makes it unconstitutional, Your Honor. I'm not asking you to rule whether you think it's that you would personally agree with the defense. It's unconstitutional because we can't even make it.
Okay. State's response.
Your Honor, first, we're dealing with the statute that is
Let's listen to this trash.
actually in front of us, not what the legislature is doing or not doing.
Yeah, I can't consider that. It may be this case that they might be looking at that, whether it's enacted and signed by the governor. That's another thing. But it's a good argument, but it's not. I can't base my ruling based on that.
Yes, we're dealing with the law that's in front of us. And this law, while the statute has been amended, the knowledge requirement was always part of the statute. It wasn't just an intent statute. There was the knowledge requirement that was in existence in the statute back when Brown was decided. And so that's always been a part of this. But what the court has said is that the statute is constitutional. talking about what happens across the country doesn't matter again, because we're dealing with what the law is here in Arizona. And the law in Arizona, it's regulating conduct, which may include a blend of speech and conduct, as the case law talked about, but it's still conduct. And what that has said is it's looking at criminal liability based on the manner in which certain communication is conveyed and the underlying purpose for the communication. So the purpose is built into that, of looking at that. And there's also, it has to be directed at a specific person. And then there's also a reasonable person standard. So it's not just, that the victim in this case, whether she's, been harassed by it, but it would also apply the reasonable person standard, which is how they get around and find that this is a constitutional statute. The constitutionality has been upheld. It's already been litigated up high, and what they're talking about.
And let's just make sure that we touch on it. In finding the statute constitutional, this is before the legislature edited it and took this portion out. The court stated, by specifying the intent with which the call must be made and the nature of the language provided, the statute clearly demonstrates that the prohibited activities find no protection under the First Amendment. By specifying the intent. Okay, seems important to me.
The intent, that wasn't what was discussed in the case law, that the intent wasn't the issue. And with the knowledge requirement.
Did she just lie in open court? She just said that. Wait, let's listen to that again.
Statute. The constitutionality has been upheld. It's already been litigated up high. And what they're talking about with the intent, that wasn't what was discussed in the case law, that the intent wasn't the issue. And with the knowledge.
The intent wasn't the issue. In finding the statute constitutional, the court stated, by specifying the intent, it's even italicized, with which the call must be made and the nature of the language prohibited, the statute clearly demonstrates that the prohibited activities find no protection under the First Amendment. Okay, Rachel. I don't know whether to be... to think that the prosecutor she's going, or the defense attorney she's going up against in this murder trial that she's currently on is lucky, or if he's just, how many rules did she break in that case? And are they just did they just take it? Is that what the defense attorneys do in Pima County? They just take it because they're scared. They're scared that somebody might come after them for doing their job correctly. But this bitch just lied. She just lied. She said they did in finding it constitutional. The intent, that wasn't what they were talking about. Okay, Rachel.
Requirement. Like I said, it was part of the original statute. It's still present. The knowingly requirement is still there. And the knowingly requirement has the showing that he has to be aware that it's doing this. And
is he aware that he understands it's harassing? Or only, let's give the example where he's calling someone all the time. Does he only have to be aware that he's calling, or that his calling is harassing to somebody?
So I want to be clear, because the court referenced this repeatedly commits an act or acts. That's the first part of harassment. He's actually charged under A1, and that's under the or, so it has to be the person knowingly commits any one of the following acts in a manner that harasses, and it's under 1, which is contacts, or in this case, causes a communication with another person by verbal, electronic, mechanical, telegraphic, telephonic.
Causes a communication. This is the reality that this is the woke reality that Rachel wants us to visit.
Written means. Contacts, or in this case, causes a communication with another person.
Causes a communication. He's never, he hasn't told people to do it. but he is somehow causing it. Simply displaying the information is enough. Shannon is a subscriber to the channel. Lane posts a video. Shannon gets a notification. Lane caused the communication with Shannon by posting his video. I think, but don't charge YouTube. We're not going to charge YouTube. Let's charge Lane for posting the video, and Shannon got the notification. He caused the communication. Okay. All right.
By verbal, electronic, mechanical, telegraphic, telephonic, or
What
written
up, Dasfoot?
means.
Thank you.
So if he is, so it's looking at, is he aware that he is causing the communication with another person? And then you have to also have that harassment under the 132921E. And that's where I said it has to be directed at a specific person. And then there's also that reasonable person standard that has to be reviewed. And so these things are all still in existence with the statute. So the portions of the statute that were discussed in raising whether it was a constitutional statute has already been litigated, and those are still in play in the statute that's in front of us today. And so there's nothing new, and the defense has the burden of proving that this statute is unconstitutional, and they haven't met that burden. It sounds like his argument is, it's being dealt with at the legislature and wanting to talk about what they are or are not intending and what they're doing, but that's not what's in front of us. And so
What if a person is just very self-aware that their conduct is very offensive to another person, but they're...
And then what if they're really self-aware and they know that the person's a fucking state actor and that they're allowed to do it? And we're talking about something that didn't even happen. He didn't even reach out to her. We're talking about something that he's not even doing. We're talking about some hypothetical where he's responsible for other people's actions. That's what Rachel's talking about. He's some Svengali that's got the strings on everybody and can pull the strings and get everybody to do what he wants them to do with mental telepathy, because it's certainly not, he certainly doesn't say it in his YouTube videos.
Intended to be that, just that they have very poor social skills, so they can't communicate effectively with other people. Would that still be violated violative of the statute?
Well, then I think then you would have a problem with the knowingly. Then we would have difficulty proving that because
they know
of
that
that.
they're calling. They just don't understand that their calling is bothering the other person.
That he has to be aware that he's committing an act that's in a manner that harasses and causing that communication.
Okay, that was my question. Is it just knowledge of calling, or that the calling is seriously alarming to the other person and to a reasonable person? Does he have to have some awareness that what he's doing is offensive to the other person?
Well, he has to be aware that he's committing one of the acts in a manner that harasses. So it goes to both portions. It's not knowingly just committing an act. It has to be an act in a manner that harasses. And the manner that harasses has to be directed at a specific person, and it would cause a reasonable person. So that knowingly goes to that portion as well.
Okay. And what about the argument that Mr. Parvin makes that that there's no affirmative defense of legitimate purpose, which I believe there is in the civil harassment statute. So again, what if the person's believing that they're calling an elected official to complain about some public policy matter, and they say, well, I didn't intend to harass, I have a right to call.
Well, that goes into that, once again, into that manner that harasses. And then when you look at what the definition of harasses is, that directed at a specific person, and that would cause a reasonable person to be seriously alarmed, annoyed, humiliated, or mentally distressed, and the conduct in fact seriously alarms.
And then she wants to just forget about the section of the of this where we're talking about the intent again. This is made clear by the statute's requirement that the communication must have been made with the specific intent to harass. In addition, the statute contains both subjective and objective components requiring harassing conduct to be focused on a specific person. So that must be it. Like we watched the last video that we watched was the Samantha Walker video, where he talked about all kinds. He actually told people to reach out. He said, reach out to these people. He actually said, here, hold on, I think I got the clip. Yeah, I think I got the clip, y'all. I think this is it.
This should be channel should be called Lane Myers Exposes. And I don't mean in an only fan way. In a mostly fan way. Because most of my viewers are my fans, but I got a lot of people who watch my channel who aren't subscribing or liking because they hate me, which is just as good as love. Because all good relationships require a little bit of hate and a lot of love. Because agape. But I got to get back, and so please call these fucking idiots over and tell them that Lane Myers sent. Make sure you say, I'm calling. Lane Myers gave me your number. Lane Myers. Say, Lane Myers sent me. We got to see if they'll try to charge me with some, he's telling he's on his YouTube telling them to call us. Let's see if they'll charge me with that too. Come on, rack them up, baby. Hurt and is calling Samantha Walker a cunt. I'm gonna.
So is calling Samantha Walker a cunt a crime? Is it? Because they're gonna have us believe that. Let's see, what was it again? Requiring the harassing conduct to be focused on a specific person. Okay, so they're gonna. So he only does this to Shannon, but they're gonna play a video that's a crime. This was a crime. This video was a crime. They're gonna play this video where he talks about reaching out to other public officials, and they're gonna say, this isn't the harassment you're looking for.
Because agape. But I got to get back, and so please call these fucking idiots over and tell them that Lane Myers sent. Make sure you say, I'm calling. Lane Myers gave me your number. Lane Myers. Say, Lane Myers sent me. We got to see if they'll try to charge me with some, he's telling he's on his YouTube telling them to call us. Let's see if they'll charge me with that too. Come on, rack them up, baby. Hurt and is calling Samantha Walker a cunt. I'm gonna.
Okay, they're gonna play that, and then they're gonna say, he said Samantha Walker, but what he meant was Shannon Walker. So we're gonna charge him for doing it to Shannon Walker. He harassed the shit out of her.
Annoys, humiliates, or mentally distresses. So that's where the fact that it also goes to the reasonable person standard keeps it so you've got both the subjective and the objective standard. So the subjective is
because the statute only criminalizes communications made with a specific deliberate purpose. The statute does not apply to pure First Amendment speech, but instead regulates at most a blend of speech and conduct. Okay.
directed at the specific victim in this case. So if you just have a victim who's particularly sensitive, that's where the objective standard of the reasonable person would come into play.
And what about the idea that a public official can't block or stop this because the person has a right to call continuously to basically shut down an office? Right, if you have any information, I don't know, you may not be ready to answer that. I don't know if you do or not.
Well,
I don't know shit about the First Amendment. Rachel, do you know anything about the First Amendment?
Your Honor, I think every case you're going to have to look at the specific nature. And I think that once again goes into that manner of harassment. If he was contacting her because of her role as a public official, that'd be one thing. And then you get into that's when you start getting into more of a speech thing when he's contacting because of their role as a public official. That's not the circumstance we have in this case, and you have to look at.
What? Did anybody understand that fucking word salad that she just said?
In fact, seriously alarms, annoys, humiliates, or mentally distresses. So that's where the fact that it also goes to the reasonable person standard keeps it so you've got both the subjective and the objective standard. So the subjective is directed at the specific victim in this case. So if you just have a victim who's particularly sensitive,
You've got an alleged victim that's particularly sensitive, and his name is Matt Walker. Okay. This is Rachel explaining the First Amendment to us, by the way.
where the objective standard of the reasonable person would come into play.
And what about the idea that a public official can't block or stop this because the person has a right to call continuously to basically shut down an office? Right? If you have any information, I don't know.
Why did he interject that to shut down the office? Is that what he said?
Continuously to basically shut down an office. Right? If you have any information, I don't know.
So the subjective is directed at the specific victim in this case. So if you just have a victim who's particularly sensitive, that's where the objective standard of the reasonable person would come into play.
And what about the idea that a public official can't block or stop this because the person has a right to call continuously to basically shut down an office?
I can't catch exactly what he's saying there, but Jesus Christ, man, this guy's hurting my head. These two are hurting my brain. The mental gymnastics that I'm trying to leap through to make sense of these two.
If you have any information, I don't know. It may not be.
Do you have any information on that? The judge says. We're talking about the First Amendment. Do you have any information on that? What?
Ready to answer that. I don't know if you do or not.
Well, Your Honor, I think every case you're going to have to look at the specific nature. And so
Okay, she ignored his question completely. He gave a specific example where somebody was calling continuously with the intent to shut down the office. He actually mentions specific intent to shut down the office. And this is Rachel's answer.
I think that once again goes into that manner of harassment. If he was contacting her because of her role as a public official, that'd be one thing. And then you get into that's when you.
So if Mr. Myers reached out to Shannon Walker in her role as a public official, as a state actor, Rachel's saying it's okay, I think. I think that, chat, what do you guys think? We're going to get into it a little bit, but I think she just said if he was calling for a legitimate purpose, it would be okay. Let's listen to it again.
Case you're going to have to look at the specific nature. And I think that once again goes into that manner of harassment. If he was contacting her because of her role as a public official, that'd be one thing.
Okay, well, if he was contacting her in his role as a public official, that would be one thing. This fish for brains.
Who's the judge?
Posting was done by a third, but he did.
Oops, that's not it. Where's the first voicemail? What the heck is going on? Bear with me for a second. There it is. Okay, so if he reached out for a legitimate purpose, that'd be one thing.
Special projects. Well, hi, my name's Lane Myers, 520-771-2021. I see you're a director of special projects. Well, I'd like to ask if you could approve a special project where you help me end your husband's career for being a crooked-ass cop, prosecutor, wannabe, whatever he is, hiding these cops from prosecution. I figured the U of A, maybe Stacy could help me. Maybe I should talk to you or Stacy or maybe one of these. Because, you know, my wife also is an alumni of the College of Law and is actually has taught there. So, like, we got two sides that are about to come crashing together here. So, you can help me teach your husband how to follow the law, or I'm going to take his career. So, I figured since I'm a member of the community and my wife's an alumni of the law school, that maybe I could get access to the materials at the law school in order to fight for justice, since Stacy's all about justice. So I guess I got to call Stacy next.
Okay. I mean, she works for the program, the Access to Justice. Those are legitimate questions. His wife hasn't been fired. That's the accusation that they're making. He only ever reached out because they got his wife fired. No, that's not true. This happened before that. Right? This happened before that. There was a legitimate purpose. He didn't call and talk about the specifics of his case. That would be illegal. He walked right up to the line. Right? And did something lawful, Rachel. And you guys are criminalizing it. And it's gonna be a sponsor 2.0 for all you terrible cunts.
And then you get into that's when you start getting into more of a speech thing when he's contacting because of their role as a public official. That's not the circumstance we have in this case, and you have to...
It's not? What? She does she ever admit that Shannon works for the University of Arizona, or worked? Nobody knows if she still does. Her information's still up on the public website. But they want us to believe some fantasy.
Look at the specific facts of the case. In this case, he's not contacting the victim because of what her position is when she was an employee at the University of Arizona. He's contacting...
When she was, is what they're saying, is what Rachel just said. And I think this is pretty important.
You may not be ready to answer that. I don't know if you do or not.
Well, Your Honor, I think every case you're going to have to look at the specific nature. And I think that once again goes into that manner of harassment. If he was contacting her because of her role as a public official, that'd be one thing. And then you get into that's when you start getting into more of a speech thing, when he's contacting because of their role as a public official. That's not the circumstance we have in this case, and you have to look at the specific facts of the case. In this case, he's not contacting the victim because of what her position is when she was an employee at the University of Arizona. He's contacting her because of what the position was of her spouse. And so it's not going to fall under that politically protected speech. If it did, we would be in a different situation. If he was contacting her to say, this position you took publicly, I don't like the position you're taking, as if
I can call involvement. My wife getting an independent journalist. Good morning, Shannon. My name is Lane Myers. I'm an independent journalist. I'm doing a story regarding a case that's taking place in Tucson. I was wondering if you'd like to put a statement on the record whether or not you had any involvement in my wife getting fired from her job. I'm giving you the courtesy of, I'm willing to quote you directly, but instead you guys want to hide and play games and use the legal system and hide behind fake injunctions that are going to get dismissed and all this kind of shit and try to violate my rights. I can come to the law school. There's nothing that can stop me by law. And so we can do this the easy way, the expensive way, or the uncomfortable way. But you're a member of the University of Arizona faculty. You're a public employee. I'm a journalist. I have the right to free press. I want to ask you, you can have the media department, whatever. If you don't want to, your actions indicate guilt. I'm giving you a chance to say, hey, I know it looks wild what's happening, but that's not true. But instead you want to run and hide, that's fine. You have that right. I'm not going to hurt you. I don't have nothing. But in a working capacity, I am going to, attempt to get a quote from you. And if you don't want to give a quote, then just say you don't want to give a quote. But either way, I have the right to question you. And you can't weaponize the fake court like you and your husband, or Stacy and your husband, all that shit. It's not going to work. You're just going to get sued. So, public employee, public scrutiny. Welcome to the real world. It's when you're an adult, you have to deal with scrutiny.
All right, so Rachel just said, if we were talking about legitimate purposes, then it'd be a different story. It'd be a different story.
That manner of harassment. If he was contacting her because of her role as a public official, that'd be one thing. And then you get into that's when you start getting into more of a speech thing, when he's contacting because of their role as a public official. That's not the circumstance we have in this case, and you have to look at the specific facts of the case. In this case, he's not contacting the victim because of what her position is when she was an employee at the University of Arizona. He's contacting her because of what the position was of her spouse. And so it's not going to fall under that politically protected speech.
I heard some evidence to the contrary right there. Let's hear. There actually might be a little more evidence to the contrary. Let's see. But Rachel says if she saw evidence to the contrary, then this would be a different situation.
Walker.
Hey Shannon, I know you think hiding behind the website and all that's going to stop this, but it's not. It's only going to keep going, and you're just going to get yourself and the university in more and more lawsuits and more complaints, and you're just literally bringing more attention on yourself by avoiding making a comment. If you want to make a comment for the story, you make a comment and then it goes away, and then if we contact you after that, then you have standing. But this hide and lie and manipulate and go behind back channels and have your husband try this and that, it's not going to work. Unless you quit your job at the U of A, you're going to face this public scrutiny. So you can hide your number, you can do all that. It's not going to change anything. Everybody knows where you live. Everybody knows where you work. Nobody's trying to hurt you, Shannon. We just want information.
All right, Rachel.
We would be in a different situation if he was contacting her to say, this position you took publicly, I don't like the position you're taking, as if it was a politician. We'd be in a different place. But we're not talking about a politician, and we're not talking about her role in any kind of public capacity.
We're only talking about her role in a her public capacity. Only. Did she conspire with her workmate Stacy Jane to conspire with Zips to get Lane's wife fired? Did that happen? Well, was it at the direction of Matt Walker? Was there collusion between the Tucson City prosecutor, the University of Arizona, and the federal courts? Was there corruption between those three? But you aren't allowed to ask that question. That is not legitimate First Amendment protected activity, because one of the people happens to be married to one of the other people. So you get a pass.
And I think that, once again, goes into that manner of harassment. If he was contacting her because of her role as a public official, that'd be one thing. And then you get into that.
Maybe that's it. Public corruption isn't her role as a public official, right? You're supposed to act with integrity. You're not supposed to be corrupt. So maybe that's the problem. If he was contacting her within her role, but she's not supposed to be a corrupt lying cunt. So you can't actually attack her for that.
That's when you start getting into more of a speech thing, when he's contacting because of their role as a public official. That's not the circumstance we have in this case, and you have to look at the specific facts of the case. In this case, he's not contacting the victim because of what her position is when she was an employee at the University of Arizona. He's contacting her because of what the position was of her spouse. And so it's not going to fall under that politically protected speech. If it did, we would be in a different situation. If he was contacting her to say, this position you took publicly.
What a disingenuous, lying, deceitful, corrupt snake. Rachel Stiles is.
I don't like the position you're taking, as if it was a politician. We'd be in a different place. But we're not talking about a politician, and we're not talking about her role in any kind of public capacity. And under the defense's thing is that basically they could call anybody who works for any government in any position, and just, whether it's a janitor. And
hold on a minute. Mr. Myers.
complex. This is Michael speaking. How may I help you?
Michael, is it possible to speak to somebody from the custodial staff?
Unfortunately, no, because we do not have our staff. They're not staffed here. They come out.
Do you know which department I would actually reach out to? Is it still inside is it still inside the public works that we want to direct our call?
Well, can I ask what it's regarding? Because like our custodial our facility, it's a company that comes in.
I just wanted to complain to any random. It didn't. Oh, it's a company that comes in.
Correct.
Oh, so is it a private company?
Correct.
That's very interesting.
Yeah, we have a contract with them. So we're a department with Pima County. So they're a company so they have a contract for cleaning services for Pima County. So actually, I would think maybe like procurement, because they're the ones that actually set up the contract with vendors to basically do business with the Pima County.
Do you know what private company that is?
The cleaning service, they're called Jan Pro.
Jan Pro?
Yeah, JANPRO.
Very good, thanks. Have a good day.
Thank you, too.
Good reviews.
Connect to 520-341.
This call will be recorded for quality assurance.
Oh, that's good. I don't even have to give them notice now.
Thank you for calling John Polo Tucson. This is Erica.
Hey, Erica. How you doing this morning?
Good, and yourself?
I'm doing very good. I was curious, is there a specific person inside JanPro that handles the Tucson contract?
Yes. That would be Ellen Schultz.
Ellen Schultz?
Yes.
Could you transfer me to Ellen Schultz, please?
Of course. Do you want his direct number as well?
I would like that, thank you.
Okay, it's 520-289-1855.
Thank you very much.
So give me a quick second, okay?
Thank you.
Alan?
Hey, Alan, do you handle the Tucson account?
The Tucson account?
The city account.
Yeah. Oh, City of Tucson?
Yeah, I got a question. If somebody had a problem and they complained to one of your janitors, you guys know that people are allowed to complain to them because they kind of like. I realize that JanPro is a private company, right? Actually, I'm not sure if the transfer, if it covers this. This call is being recorded. I wanted to make sure I notified you. So do the janitors know that people, if they complain, that it's a constitutionally protected thing and they don't need to be scared, that it's just, some people, they get down different than other people. They complain when they see problems.
Yeah, of course.
Of course.
Yeah. You're with the city?
No, I'm not with the city.
Oh, okay. Who am I talking to?
You're talking with Joey Payne. I'm with the Phoenix Times. Have you heard of me before?
No.
Okay.
So what's going on? What am I?
I just want. You're actually not getting involved in it. It looks like JanPro's doing a really great job in Tucson. Over 118 Google reviews. That's good stuff. And it sounds like you're doing a good job communicating to your staff that sometimes people get upset about issues of public concern, and sometimes they complain. Even to the janitor, they complain, and that's okay, right?
Sure. Yeah.
All right. Well, hey, I hope you have a great day, and you be safe out there, all right?
Okay.
All right. Thanks. Bye. Looks like the janitor knows that you can call the janitor. So, let's hear Rachel explain her way out of this one.
I did hear all your argument. She has the floor now, so I don't want you to interrupt her.
Whoa. No.
It was a politician, we'd be in a different place. But we're not talking about a politician, and we're not talking about her role in any kind of public capacity. And under the defense's thing is that basically they could call anybody who works for any government in any position and just, whether it's a janitor. And
hold on a minute. Mr. Myers, I did hear all your argument. She has the floor now, so I don't want you to interrupt her, okay? I know it's upsetting to you. No, because this.
There it is. The janitor argument's coming out now. Okay, so we just established that even the janitor knows the First Amendment. Even the janitor knows the First Amendment. But the judge and Rachel Stiles, they're fucking clueless.
Be in a different place. But we're not talking about a politician, and we're not talking about her role in any kind of public capacity. And under the defense's thing is that basically they could call anybody who works for any government in any position and just, whether it's a janitor. And
well, we just illustrated that you can, right? We just illustrated that you can, and he didn't seem to have a problem with it.
Mr. Myers, I did hear all your argument. She has the floor now, so I don't want you to interrupt her, okay? I know it's upsetting to you. No, because this is her argument. So just let her talk and don't interrupt her. Go ahead.
So the position the defense is taking is that it could be a janitor who just happens to be working for it, and that they can just call and continually leave vulgar messages. And
okay, now let's make sure that we touch that, because Lane's never left a vulgar message. We listened to all, those are all 3 voicemails. Those are the only time that his voice has been heard on her voicemail. His voice, her voicemail, we just heard it. There was nothing vulgar. Nothing. We just established that you can call the janitor. Nothing.
Statements about wanting bad things to happen to them, and then that.
Lane never sent anything that he wished that bad things happened to her. Nobody wishes that bad things happened to her. We wish that she didn't lie. We do wish that. We wish that she wasn't a liar.
Be fine. But that's not what the law states, and the law has been clear on any First Amendment issue that the free speech does not protect harassing communications. It doesn't protect that kind of communication.
And if that kind of communication is occurring, you need to go after the person that's doing that communication. That is how justice is supposed to work. That we're supposed to be responsible for our own actions. Do we live in a time now where we're responsible for other people's actions? We just saw the video. We just saw a video here. We'll play it again. And they're gonna play this, and they're gonna play this one in open court too, right? And they're not going to, nobody's going to be able to say, Your Honor,
My viewers are my fans.
I have enemies too, right? I have people that want to see harm done to me.
Most of my viewers are my fans, but I got a lot of people who watch my channel who aren't subscribing or liking because they hate me, which is just as good as love.
So if those people send one of those messages that Rachel's talking about, that's Lane's fault. Hell, if the city prosecutor sent one of those to his own wife, that would be Lane's fault. That'd be on Lane. Because now in America, we are responsible for what other people say and do.
And our statute also does not allow that. And I cited one of the cases in there. It is the Cantwell v. Connecticut case that says, although the statute prohibits certain kinds of communication, it is well established that resort to epithets or personal abuse is not any proper sense communication of information or opinion safeguarded by the Constitution. And its punishment as a criminal act raises no question under that instrument. So this has been litigated on those things with the Supreme Court as far as when we're dealing with freedom of speech in the First Amendment. That's not what we're dealing with here, and we're dealing with the Arizona statute, and the behaviors and the conduct that Mr. Myers was engaging in is not protected. Free speech is not protected under his conduct, and so that is what's being regulated, and that's what we're dealing with today.
Great. Thank you, Mr. Parvin. Your rebuttal.
Yes, Your Honor. First of all, I think the state already admitted that they're dealing with one of the sections of the listed ones, or A1. Well, now I go back. That's the very language the United States Supreme Court prohibited, a manner that. They said you can't have that. I keep mentioning it because it's very clear in the United States Supreme Court, you cannot have a statute that defines it as a manner that. That's what they didn't like. And that's why the legislature, and I realize the court can't consider that. I only bring it up to show proof that the legislature knows they messed up. That's why they're changing it, and that's why they have to change that phrase from a manner that to with the intent. Now, the United States Supreme Court won't go as far as that. They're going to say they think recklessness is the minimum. Now, again, that dealt with threats. I'm not sure what they would hold for a lesser thing of harassment. But again, the point's still valid. The knowing only applies on the front end. As the court's mentioning, you're knowingly acting. And I mean, my two examples, I'd like the state to rebut. Tell me why the person in both of my examples is not guilty as charged. That's my concern.
So Mr. Tate's position was not only do you have to know that you're engaging in communication, but that the communication is harassing to the defense or to the victim and to a reasonable person. So you do have to know, you have to have awareness that what you're doing is harassing.
See, and that's why the statute's vague, Your Honor, because I'm not sure what the jury instructions are here. Are we going to just guess and hope that I want mine to stay? Oh, no, that's not what it says. I think that's the problem is unlike the other statutes where it very clearly says you have an affirmative defense for legitimate purpose, you very, very clearly can defend yourself as saying you have constitutionally protected speech, whether it's social media, in-person picketing, anything is involved. In this one, I'm going to be guessing. I can say what I'd like the law to be, but the state's going to object saying that's not what the statute says. You don't get that jury instruction. That's what makes it vague, Your Honor, is when you read the statute and you're a defendant, and as I mentioned, how are you supposed to know how you're breaking the law? As we're discussing this now, it's not clear. Is it knowing? Where is the knowing part? And I mean, that's the real concern, Your Honor, is an ordinary person of ordinary intelligence is not going to know when they are not breaking the law. And Mr. Myers reviews statutes daily. He makes videos about this explaining why he's within his rights. He very clearly is negating the knowledge here when he tells his viewers how to defend themselves and what he's doing. And that's the problem is he's relying on the statute that allows legitimate purpose, other definitions. But then here you go with this other definition that is completely different. It doesn't have an affirmative defense. And I keep bringing back my examples because, again, I want to know why that person's not guilty. And if they're not because this assigned prosecutor doesn't want to prosecute that person, That doesn't mean a different prosecutor might want to. And here's another problem. Now you got to depend on your city for politics. Well, maybe you're one of the few in the minority and you disagree with the politics of your city. Now you get a jury of your peers who doesn't like your politics. Oh yeah, you sure harassed that politician, all right, guilty. You knowingly made a video and you told people to contact this person, and then other people did, even though you personally didn't threaten them, you didn't make any bad comments, but other people did, and they watched your video, and we don't like your politics, we like his politics. You definitely harassed him, guilty.
Politics aside, that is where we're at. I mean, does anybody think anything other than that?
You don't get to then argue a defense of, hey, but that wasn't my intent, or that wasn't my purpose. You're still guilty. You're at the mercy of a jury agreeing with your interpretation or your policies, or else they're going to find you guilty under the statute, Your Honor. I mean, they're required to, because you did make that video, people did watch it, and they contacted this person. Now, you didn't tell them to make threats. You didn't tell them to say bad things, but they did. And now the state wants to put that back on you just for exercising your First Amendment rights. And again, I don't know why we're talking about the facts here. That's not what it's about. The argument today is whether Mr. Myers even has the opportunity to make this argument to a jury. He does not, Your Honor. And if you're saying he does, well, now we're rewriting the statute and trying to guess what the legislature meant. And that's the real problem. I would love it. If you want to give me every jury instruction I want here, I'll tell you how to write the statute and what I'd like it to be. I'm fine with that. We'll go to trial on our jury instructions. But the state's going to object, and they'd be right to object, Your Honor. And when we have a problem like this, that's why it's unconstitutional. And that's the whole problem.
And it's a big fucking problem. Right? Because the Parvin's exactly right on this issue. They're gonna say at trial it doesn't even matter. She's gonna say, don't believe your ears, don't believe your eyes. This purpose is not legitimate. He's doing it because it's the prosecutor's wife. Never mind that she's a public official. Never mind these are legitimate questions. And let's see the jury instructions, right?
And I really want you to review the case that I've cited, look at the examples, look at how the United States Supreme Court specifically ruled this phrasing unconstitutional. And I think the court will see the problem here of why this statute is applied, not just to Mr. Myers, but everyone, is unconstitutional, because it's kind of scary. How do you know? Is this person going to, be mad at you and prosecute you because you left a bad review? And look at the Brown. This is what I have a problem with. The state keeps saying that Brown ruled the statute constitutional based on the manner that or conduct, but that's not what Brown ruled. In fact, one of the rebuttals, it must have been a very good defense attorney to bring this up, said, we have some concerns. This is unconstitutional because look, what happens if you deliver bad news? If you critique a politician or critique a restaurant, it gave several examples of, wow, this could be a problem. You could be found guilty for this. You know what the Court of Appeals said? It said, nope, that's not going to happen because the jury has to prove that you specifically intended to harass. They ruled it a non-issue. They declined the defense's rebuttal because they said it's not an issue. And then they even quoted other similar statutes that also require specific intent. That's all that's needed. The rest of it may still have problems, but when you can go to a jury and argue, hey, this was not my intent. I had no intent to harass. Here's what I actually wanted to do. I wanted to protect children, as I mentioned in my example, or I wanted to get this law changed and represent the minority. Then, even though you potentially did cause communications and maybe other people harass this person, the jury can find you not guilty because they understand your argument that you have protected speech. You did not have intent. That solves the problem. Now, I would like it a little better. I think it needs to have the affirmative defense. But what I'm saying, Your Honor, preferably both, but you need at least one of them. I think a specific intent would cover that affirmative defense based on how the Brown ruled. But I guess I have a real problem with the state trying to say, oh, let's get rid of that part, and it's still constitutional. Because you don't know how the Court of Appeals are ruled. Because that statute wasn't before them. Again, this is the first opportunity for a court to rule on the constitutionality of this current statute. And I have a real problem with the state arguing that we get to just say, oh, use this parts, when that court did not have the full knowledge because they didn't know what this statute was. Does that make sense, Your Honor?
Yes.
Okay, thank you. And Mr. Myers, if you want to add.
Mr. Myers, you don't need to repeat.
I know. I just
Go ahead.
because we keep talking about Brown, right? Well, that was a case in this court. Okay, Brown, State versus Brown was a case in this court, and then it got appealed. So I feel like, I've read Judge Dawley. I read Judge Dawley's and this Court of Appeals, and that's what I'm trying to say here is I feel like they're intentionally obfuscating around, beating around the bush, for lack of a better term, because here's exactly what Judge Dawley said. The real question is whether the state has passed a law that has a legitimate purpose that is
Slow down.
that is sufficiently narrow and that doesn't just arbitrarily and over broadly interfere with community. He denied Brown's. Okay, Brown made this argument in the trial court, and this is what Judge Dawley reasoned when he denied the motion. Okay, in trial court before we get to the appeal court thing. The real question is whether the state has passed a law that has a legitimate purpose that is sufficiently narrow and that doesn't just arbitrarily or over broadly interfere with communication and a person's right to speech. The next question is, can I interpret it in a way that it will be constitutional? And the fact that the statute specifically requires an intent that the person is harassing is not sufficient to prove the contact was made or speech was made. The state has to prove the specific intent that the person is harassing in the process. And I think that's what, in my opinion, saves the statute. So that's what he said, right? And then the appeal court picked up on what he said and said, we're going to take it even further and say that the requirement of the intent, and this is quoting the appeal court now. Indeed, interpreting the statutory language to permit prosecution for constitutionally protected activities would require the state and the courts to expand the statute's reach considerably beyond what the legislator intended. Accordingly, any misuse of the statute, like we're happening here, if such occurs, can be addressed and cured through case-by-case analysis of specific facts. That's why they upheld it. They found that when Judge Dawley reasoned that the only thing that saves the statute, because Judge Dawley would have ruled it unconstitutional and then it would have never went to the appeals court, but he said, can I interpret it in a way that it'll be constitutional? And I think that the state has to prove intent, his quote word for word, I think that's what, in my opinion, saves the statute. That's gone now. That intent is gone. So if Judge Dawley had this before him, he would say, well, it doesn't say intent. So that literally is his word for words. He asked, can he interpret it in a way that can be constitutional? And he determined only because of the word intent. And then the appeal court upheld his ruling because, he found that because of the word intent, then we can say, well, he clearly had an intent. Well, we can't do that now. And like you said, you can call public. They're trying to get into the.
And we're going to watch Metcalf completely ignore it. Hopefully in this reading, he's going to do more reading, I guess. I don't know that he read this. I mean, intent it's to me, it seems like it's a pretty big part of this appeal decision, right? They're talking about the intent, how the intent is pretty important. But not Shannon Walker. Anybody else, it's okay.
We can't though, but she is a public employee. That's what I don't understand what they're talking about. Of course she's a public employee, and I called her before my wife got fired, not after. And that's that's the evidence or whatever. But here we're talking about the statute, and the trial court said the only reason that I'm going to deny Brown's motion in Pima County Superior Court is because it has the word intent. It specifically requires an intent.
Okay. All right. Thank you, Mr. Myers. So we have the motion to dismiss that Mr. Parvin filed in CR 2025-1454, and then that Mr. Myers joined in 2025-1060. So the argument applies to both cases. I believe, first of all, State v. Brown is an appellate case, so it's binding authority on this court, and the standard there says that in order for something to be constitutional and not be unconstitutionally regulating speech is that criminal liability has to be based on the manner in which a certain communication is conveyed and the underlying purpose of the communication. They then said, the Court of Appeals then said that it's met by specific intent to harass, but it doesn't require specific intent to harass to make it constitutional. That's just what the statute said in that case, and they said that passes the test that they had set forth. In this case, the statute currently talks about knowingly harassing another person and defines harassment. So I'm going to deny the motion to dismiss because I think the knowingly harassing is sufficient to address which type of conduct is unlawful under the statute. Don't interrupt me. Under the statute. So those two motions are denied. Let's go to the next motion.
They're just denied. I'm gonna follow this binding appeal where they talk about the intent in finding the statute constitutional. The court stated by specifying the intent, man, these people. Where's this judge at? I mean, on the First Amendment. I mean, what do we got to do here to get a judge that... Have we run into any judges out there that have a clue? I don't even know if Riojas was... he should have dismissed it earlier too, you know?
So there are two motions.
Can we take a brief 5 minute just so I can calm Mr. Myers down?
I'm just saying, but how would somebody know
Okay.
they're asking?
So, okay, Mr. Myers, I've made my ruling. If you don't like it, remember, hold
That's why I
on.
was whispering to him.
Hold on. If you don't like my ruling, you always have a right of appeal, okay? So that's just my ruling. Let's go on to the next case. So, Mr. Parvin in CR 2025-1454 has filed two motions with respect to the multiplicious indictment. One as a stalking count, and then I think the other one is as to the other count. So, Mr. Parvin, why don't you argue those next?
Yeah, so, Your Honor, and
Unless you don't want to do those today, or
We do.
we're gonna do them. It's just my concern is I want Mr. Myers to got the same problem in the other motion about so many different charges for the same thing. It applies to his case too. That's my only concern.
you want me to find that he's joined in those motions?
Please.
Yes, at least
Okay.
only one. Yeah, that.
You don't have any objection to that, do you?
No.
All right, so I'll find that the motions that Mr. Parvin's filed, one is motion to dismiss count 6, stalking, already multiplicious as to charged offenses in the earlier case, and the motion to dismiss the multiplicious harassment counts also apply to CR 2025-1060. Mr. Meyer joins in these two motions without objection. Okay, go ahead, Mr. Parvin.
Well, in this case, it's one series of conduct for everything. As I think the court has heard that this is a question of whether this is legal or not to protect its speech. It's not fair for the state in this particular case, because it's one course of conduct, to charge it 20 different times or whatever they did just to try to prejudice a jury into getting more convictions or saying it's a bigger issue than it was. Obviously, and again, I'm not sure what we're going to do for jury instructions now. It's going to be a problem because of this we already talked about, but either the speech is protected and he had a legitimate purpose or he didn't. The state does not need to charge that 20 times. And even indictment, I've been trying to figure out which one applies to. Is it which days? It says back to back. It's really one act, and the state is trying to go fishing here and try to do this over and over and over again when really it's only one course of harassment, Your Honor. It's one course of stalking. And at least The reason I brought it up is, in the first case, they charge a bunch of harassments, only one stalking. They acknowledge it's one course of conduct. And some of them even a couple months apart. Yet somehow, all of a sudden, only like, 13 or 14 days, whatever, I think it was 19 days, that he stopped. So they're saying he didn't stop, even though there was a break. But that's one course of conduct. But yet somehow he stopped and started again 19 days later. The state, that's my problem.
Mr. Parvin, let me ask this. Yeah. So the state charges several acts of harassment. They got an indictment. And then after the indictment was returned, they allege new acts happened. So how are you saying that he has immunity as to those new acts because they happened after the indictment?
No, again, my motion, they're separate because that's why it's tough because in that case, I'm only talking about the two in my case. They're back-to-back videos. So what this was, the state alleges, and we disagree it's harassment as the court knows.
Are you saying that they're multiplicious as to respect to the first indictment or only as to themselves? There only should be one count in the second indictment.
In my motion, I was talking only about the two at issue and the case number I'm still the assigned attorney on.
Are you saying that those two charges should just be one count?
Correct. Because there was two videos made at the same time, back-to-back. That's what it should be, one count.
Okay.
There was not two separate acts.
For the stalking?
No, I'm talking about their harassment. Only the two in this video.
I thought it was about stalking.
That's what it's both. I filed that one. I don't know if you saw that one. Same argument connecting the two cases. This is the one true course of conduct where I'm saying the state magically thinks that even though they said, a couple months in advance it's one course of conduct, that all of a sudden he stopped for 13 or 19 days and then started again. That makes zero sense, Your Honor. That is the same course of conduct. There shouldn't be two separate stalking counts there. And that's why the definition of stalking is a course of conduct. You need more than one act. And that's the other problem, is that as far as the two harassments back-to-back on this case number, you need more than one act. So I would agree the state could charge it as harassment, but for the two together, not just the one. So that's why it's...
So, again, remind me, in your case, there's one stalking count, right?
There's one stalking, but I'm arguing it was an unnecessary indictment because it's already covered from the current ongoing alleged stalking.
Right, but it's acts that happened after the indictment of the first case. So how do the state address that?
It's not acts that happened. It's ongoing conduct that hasn't stopped.
Would it? Well, but would it be?
The state would amend what the state would do is, again, we just disputed stalking. We dispute that. We're not saying it's not. In fact,
right.
I forgot to bring it out. I'll bring it up later. We'd like an extension on any rematch for grand juries. We're still looking on that because these motions, so many motions here. That'd be part of that argument. But the point is that this is one course of conduct that hasn't stopped, which is why the state should then be amended. If they want to include up to today, they should amend the first stalking, and we'd have no objection to that, to include ongoing conduct. Because either it's illegal or it's not. It hasn't stopped. That's the problem. Whereas the state wants to say, no, he acknowledged this was wrong and stopped doing it, and then he felt like doing it again a second time. That's what they want to tell the jury. Well, that's not true. He's acknowledging he's doing it because he doesn't believe it's illegal. That's one course of conduct. It's not two separate criminal acts.
Okay. And then as to the two counts of harassment in the new indictment, are you saying that those should be one count or that they should just be covered by the first indictment? That
one was sufficient pause. I would say this would be one separate additional count for these two.
Mm-hmm.
We're not. I understand there's slightly different arguments. The stalking I'm saying is there was no new crime. It's the same course of conduct.
Right.
For harassment, this was an additional act, alleged additional act, but it was the same additional act. There weren't two of them.
Okay.
If that makes sense, Your Honor.
Yes, I understand. All right, Ms. Stiles, your response?
Your Honor, I cited State v. Rios, and that case is important because it talks about when you have a victim-directed activity. In that case, it dealt with someone who was sending multiple text messages to a victim, and the court found that each text message, even though it was in a one-day period, each text message was it could be a separate harassment count.
That's the Rios case?
Yes.
Uh-huh.
And so this is victim-directed. These are separate acts. So in talking about the two new videos, they're on separate days and they're completely separate videos. So they're separate acts from each other that are being directed to cause this communication with the victim in this case. And so they can be charged as separate acts.
What about the argument that the statute requires multiple acts?
So we just talked about that again. It doesn't require multiple acts. What I talked about is There's the first part of the statute, which a person commits harassment if the person knowingly and repeatedly commits an act or acts. That's one portion. And then it has the or. The person knowingly commits any one of the following acts in a manner that harasses, which again is talked about in Rios. And that's the A1, the contacts or causes a communication with another person. And it gives the different means you can do so.
Okay.
And that's the or is a separate thing, and that's reflected if you look at prior versions of the statute where those have always been separated out. So for this one, it doesn't require that repeated. So that act, that's when he's knowingly committing an act that's in a manner that harasses, causing the communication, that's its own separate act. And so we can charge those as separate ones.
And as to the stalking, why not just add that, amend the indictment of the first case to add the additional acts?
So, Your Honor, the stalking it's another broken up one because there has been an intervening thing.
She's such a dirty snake.
Time frame did stop, and then there's this intervening act where he was indicted on charges, and then after he was then given release conditions, he started again. So we do have that intervening act. So they are separate. So just because we could do this really broad range doesn't mean we have to, and nothing requires that. And we do have that separate time, and we have a big separate act that happens in between there, this intervening event before the new time frame starts. And for the stalking, we have to have at least the two different incidents, which we have in this case, which is why there's also this additional stalking count.
Okay. Mr. Parvin, your response, if you could address that Rios case, or your rebuttal, I should say.
Yes. The state's right about Rios. The problem is that I wouldn't say they're misleading the court. They're just making their arguments. Rios dealt with actual separate incidents where the person's aware, yes, I did it, I stopped and did it again. And that's every trial was that there's a start and an end point. So it's different than when they sit, because there's an actual victim, that needs to be individually charged. What makes Rios distinguishable is in our
That's right, Vicky. You just caught a count too.
case, there was no stopping, as in this was, and the statute says it requires a series of conduct, multiple acts. So especially the stalking, is the state really arguing that he stopped and then started to his detriment? If he stopped and then certainly he's not going to start again after potential release conditions. No, he kept doing it the whole time. He kept making videos because he believes allowed to, and this is not stalking. So this is one course of conduct. Now, that's for a jury to determine whether Mr. Mars is correct or not. The problem is with doing this twice, the state is going to tell the jury, oh, he acknowledged it, he stopped, and then he started again and did a separate crime. That's how they want to tell this story to a jury, that this was two separate crimes. It's not, even if the jury thinks it is a crime in the end. And furthermore, this one only had one act. If it requires a series of conduct, they're going to say stalking again. There's not a course of conduct again if you're going to start it over. If the state wants to start over, they don't have that series of conduct again. Same problem with harassment. And again, I think that's why I'm conceding that this does not apply to the first one for my harassment motion, because that was a separate act. In that case, and I'm not conceding it's harassment, we don't think it was, but there very clearly was a stopping point in the sense that there was a couple breaks. He didn't make any videos, but he may be upset over it, but then he did another act. There was a clear defining point where a separate act started again that could be considered another harassment, although again, that's a problem as we've already discussed. But for this, for the two at issue, these were back-to-back videos. It's the same exact act, making two videos about how upset Mr. Myers was.
Sassy.
That he's wrongfully charged.
You're looking at life.
We'd get to that at trial if the court permits, which is a problem, as I mentioned. But that is only one charge, Your Honor, not two. It didn't stop and end the next day. It was one harassment. Same with the stalking. Same course of conduct. Please read the stand for saying he never stopped. And honestly, he'd probably still be doing it because he thinks he's allowed to. And he may be right. Mr. Myers may be right. But he's now respecting the fact that the state has, saying what's going on. He's stopped, but not because he wants to, because he believes he's in the right to do so, Your Honor. If that makes sense.
Okay, Mr. Myers, what do you want to tell me
about the stalking? I didn't make a video about Shannon Walker between October 21st and January 22nd. Why didn't I get 2 counts of stalking right there? That's months in between, not even 19 days. If they're going to say it started and stopped, well, it stopped October 21st. and then it didn't start again until January 22nd. That's a lot more than 19 days, so they could have hit me with a new 2 stalking counts right there too, but they didn't. They could have actually.
Those will come next week.
Because I didn't contact her from September 12th to October 15th. That should be 2 stalkings. October 21st to January 22nd. That should be another count of stalking. January 22nd to February 22nd, new count of stalking. So I mean, how can 4 months go in between and it's 1 count, but 19 days and it's not 1 count?
We just want a fair trial, Your Honor, on the actual alleged act.
All right. I am going to deny the motion to dismiss the stalking count and the multiplicious harassment counts. I do find on the Rios case that each act of harassment can be charged as a separate crime. And with respect to the stalking counts, there was the intervening event of the indictment, and I don't think the state is required to just amend the indictment. They can charge it as a new stalking count. So that addresses those 2 motions.
Yeah, we all know, Metcalf, that does not address those 2 motions. You woefully and pathetically fell short of addressing those 2 motions. Your simple statement of denied is, and then citing the bullshit that Rachel brought up. Rachel is half retarded. I mean, and that's insulting to, like, retarded people. You know what I'm saying? We all need to call Rachel and confess our sins. But she doesn't ever... Actually, they never even patch me through. I get sent to the detective line. And last time I called, they told me... I might have this wrong, but... I think they told me they were going to send me to the detective line, and they just sent me to the nuisance voicemail. That's how I know about the nuisance voicemail, because I've been sent there so many times.
Let's next go to, I'll do the bail thing last. Let's talk about
I'm going to do that last, so I can hold you in suspense and then just deny it at the last minute. For no real reason, no real legitimate reason, because here, let's take a look and see. Because these 3 videos here are stalking, I guess. I don't know what the stalking is. I really don't know. I don't know. I mean, but let's handle the bond last. It's so his freedom is so unimportant to Metcalf. And Rachel is just cruel and unusual, conspiring with Matt and Shannon to keep this guy in jail because she got her feelings hurt. Or really, it's not even that. It's that Matt got his feelings hurt. In the court, staring people down like he's a tough guy.
Legal resources. I'm trying. I have the state's response.
Can you set a hearing for that?
Oh, hold on. I want to.
It's a notice, not a hearing or a motion.
All right.
I don't feel it's fair without bringing the people involved in and putting them under oath.
Did the defense file a motion respecting legal resources or just raise the issue?
No, the state did.
Your Honor, it's the defense raised it in the motion regarding the bail eligibility.
Right.
They raised the issue, so I made sure to provide the court the notice and the defense notice of what has been provided.
Mr. Parvin, you want to argue that as part of the bail, or I want to address, because I want to make sure that he does have access to legal resources. So
I want a hearing.
Go ahead, Mr. Parvin.
I'd like to pause. I'd like to get ready for the main hearing, which is the bail hearing today. Why I believe we're entitled.
All right, 2:13. So there's about an hour left of the hearing. Metcalf goes to the legal resources, which he thought were important, right? But let's see if he thinks they're important at the end.
Stand the defense notice of what has been provided.
Mr. Parvin, you want to argue that as part of the bail, or I want to address, because I want to make sure that he does have access to legal resources. So
That's what I want to hear.
He doesn't have access to legal resources. He doesn't. He doesn't have access to legal resources. And spoiler alert, at the end of this hearing, he's going to go back to jail for 2 weeks with no access to legal resources. But it's good to hear that the judge is so concerned about his access to legal resources that he kept him in jail without any legal resources. Great job, Metcalf.
go ahead, Mr. Parvin.
I'd like to pause. I'd like to get ready for the main hearing, which is the bail hearing today. Why I believe we're entitled to bail or rehearing, because this could be a moot point after. I don't know, but I'd like, that's really the heart of it, is why I believe Mr. Myers should get released on conditions, and
Okay.
I'd like to prepare for that, because this may or may not be a moot point after that, and I'll be addressing some of that in that.
Okay,
hearing.
so let's go to in the new case, CR 2025. All right, before we get started this morning, I'll read the notice of crime victims and I'll call the first case. If you are the victim of a crime with a case pending before this court, you are advised that.
All right. Metcalf going live. Guess I'll miss that hearing.
454, motion for rehearing on bail pursuant to 7.4C. And Mr. Myers, this only does apply to the new case because you do have bail in the older case. So we're just going to hear from Mr. Parvin.
Skipping this notice regarding and stuff.
No.
Well, we're going to address it as part of this. But I'm just going to hear from Mr. Parvin in part because it's only the second case and just to conserve time. Okay. So go ahead, Mr. Parvin.
So I think the first hurdle here.
So it sounded like the judge just said, we're going to punt on your legal resources hard. We're going to punt hard on them.
Is I need to prove this court why we're entitled to a rehearing. And I think I laid that out in my reply, as well as the introduction of my original motion, is that this is a separate court than the consolidated court. What I mean by that is we disagreed with the new charges. We disagreed to how it happened, but we had to act quickly. I was up almost all night trying to prepare an argument on short notice for that bond hearing. We got it done, but that was in a limited jurisdiction court before the indictment under a separate case number. I think it was, I can't remember exactly, but it ended in FE for felony. It was in the Pima Consolidated Court. Yes, this court was used to facilitate a.
I feel like this whole upcoming hour or 57 minutes ends up being just a colossal waste of time because they should have just set the hearing, and they didn't even set the hearing. I guess I don't even remember if they denied it at the end, but he's owed a hearing.
But it wasn't under our Superior Court case number. It was still, everything was filed in the Pima County Consolidated Courts. Thereafter, there was an indictment.
I've never seen violence from Lane, but let's give the alleged murderers bond. Let's keep Lane in jail.
And then if you look at the file, it was all transferred to the Superior Court for arraignment. That is why I think the rule very clearly says when you get a transfer to a new court, then
all of our calls collectively probably were close to the amount of calls Lane was giving the Pima County Prosecutor's Office when they were pursuing the first set of bullshit kangaroo charges against him.
You get a rehearing. Now, I'm not asking this court to do a full evidentiary hearing, but
Why not?
hold on, Mr. Myers, because a lot of that is already litigated. The court can use a lot of those facts. Now, there may be new stuff where testimony might be able to happen at any rehearing. But so I'm not saying we get a complete do-over on everything that's heard. That'd be a waste of time because we're not disputing that. But Mr. Myers is entitled to a
I think there's some disputing what the detective said. Wouldn't you guys say?
hearing now that we're in a different court to address the same arguments. And the reason that got me thinking is I know that this court is actually the appellate court over the justice court. So I thought about what are our options if we disagree on short notice. We could special action, but we don't have to. And that's why I think the rule is created that way. It acknowledges you've got a couple days only to prepare for that hearing. You don't have a lot of time. So that's why once you are transferred to the Superior Court, the rules allow you, rather than special actioning, to then apply for a rehearing.
So, to Sassy, I'll address that. Technically, what is being talked about right now is just the post initial bond cases. So he hasn't motioned to become his own attorney on those charges yet. So Parvin is the attorney of record. So he's not supposed to have a voice right here. The fact that this is also strange, but the fact that he ends up getting a voice and what he says is simply, these are the rules, follow the rules, right? As always, Lane comes through knowing the rules like they're right in front of him. These are the rules, follow the rules, and then the judge just ignores what he says as if he didn't say it and as if it's not true, right? So that's why Parvin's handling this, and they silence him. I'm not a big fan of it, right? But it is what it is, and I'm glad that he was given the opportunity to say what he did say, because if they just went to that rule 4 minutes ago, right, and just read that rule and said, oh, okay, pretty cut and dry, let's set the hearing, and then they could move on to whatever the hell, then they could move on and spend the next 50 minutes discussing his lack of access to legal resources, when Rachel lied several times in open court saying that he had access to legal resources. First, that he had access to a law library that didn't exist, and next that he had access to legal resources on the tablet, which he does not have. So Rachel's just batting 1,000, and they just lap it up. But who's right in the end? He read the rules. Just follow the rules. Give him the hearing. Let's move on to the next thing. And maybe he'd have some legal resources for the next 14 fucking days.
With the assigned judge, address the arguments again when you've had more time to prepare, when you know more of the facts. And I'm not saying this court needs to act in appellate capacity, because you don't this time. But because you don't need, but the court is free to make its own findings of facts. And I want to say, here are my concerns. I'll respect that court's ruling, but we were on short notice. I don't think Mr. Myers got a fair hearing on the finding of fact on whether he was on pretrial release. I made a very clear argument of why we thought that it was so heated, it wasn't official till Monday, and nothing happened till Monday. And yes, that judge, though I disagree, found that an alleged felony might have happened, but didn't really rule, if you listen to the audio, on whether our argument was correct when it became official.
Let me ask this.
There were no findings of fact on that.
What was the issue on the bond hearing?
Exactly, Joe.
That he
exactly.
Was on release when he was charged? I mean, you don't look at and he was indicted, right, on the new counts, or just charged?
It doesn't matter if you're indicted. You have to be actually on pretrial release when that becomes official. So the argument was that similar to how this proceeding, before we could special action or appeal, we can't do that until there's a final order from this court that's official. Even though you've already ruled, it's not official until that minute entry comes out with the final judgment saying, here's my ruling, and now we're free to go to the Court of Appeal. We need to. It's similar here, is that the argument I made, and I still think it's a valid argument, is that it was so heated, there wasn't time to process, the minute entry did not go out, it was not official until Monday morning when all of a sudden, hey, here it is, here's the minute entry, we got to deal with this. And again, that judge, and I respect the decision. I suppose I meant is she took her time. She reviewed evidence. She did go back and spent quite a bit of time reviewing the evidence. So she did a thorough job there, but she missed this point and did not really make any findings of fact on that argument. And if you listen to the record, nothing was mentioned about it, of when it became official. And I know this court has done civil before. It's similar to that. Is you need a final judgment before it's an official order to appealable. It's the same thing. Is there's a reason it gives you that break. Another example, when you're convicted of domestic violence and you lose your gun rights, they don't just say you're guilty now for owning a gun. I think they give you at least 24 hours. They say no questions asked. You have time to process it.
No, Joe, I think, I could be wrong, but I don't think you've been here the whole time. So I just want to correct one detail. It's just like a text. The state, they're saying, there's no legitimate purpose because there's just no legitimate there's no legitimate purpose. But the text that he sends is she's subscribed. So when he publishes a video, she gets a notification, and that's like the text, you know what I mean? And she's being notified, oh, there's new content. It doesn't matter, what it's about, but it's all about, everything's about her, right? Even astronauts and pediatricians, in the end, it's all about her. So I just wanted to correct that, just small detail.
It's not official till tomorrow. Do what you need to do. It's no different here. There has to be a cooling off, unwinding, processing. You have to see in writing in that minute entry that these are the terms. It's official, because the law gives you that. You need time to process. You heard how Mr. Myers is upset. Anybody. I'm not saying the court was incorrect necessarily at this point, but yet I'm saying you need time to process that. That's what it gives you. You're upset about the hearing. Things are going to happen, and then the minute entry comes in, you read it, you got to deal with it, and then it's official. And
let me ask, in the original, he was indicted, was he summoned on the indictment? The indictment was the first thing, right?
Correct, but it's not, again, the way the law defines pretrial release, it's when it's official.
So he appeared for arraignment. He voluntarily showed up, right, on the summons?
Yes.
And then the judge holding the arraignment released him on conditions of pretrial services, right? At the hearing?
It was heated. There were a lot of things said. I don't know if they were necessarily understood because of how there were security here. There were people that didn't like Mr. Myers. They had to protect Mr. Myers from these people. I don't think it was necessarily official with the terms until the minute entry came in. You could see it in writing. That was the issue.
And typically, when you have, at least in this court, when you have release conditions, there's a form that's filled out and given to the defendant at the hearing. Did that not happen?
Yeah, that would have
They
been.
took me out, so that they made me go out first, so then the victim could come after me. And that was like I had counsel, so I'm assuming it would have been
Alleged victim.
So are you saying, Mr. Parvin, that he didn't get a copy of the release conditions?
Saying that part may not have been addressed. I know I immediately talked to him on Monday morning about this, and it stopped. That was the whole argument, is the conduct did stop right away after Monday, and we said, hey, what you doing? There's a minute entry here. I think that may have been a disputed fact. And again, that wasn't addressed last time. Mr. Myers didn't testify.
I want a hearing.
But
Okay,
again, that would have been, again, I thought, but I want to make argument today is the first proof that we get a rehearing. I just hope the court would agree that based on the rules that we are entitled to rehearing the transfer courts because I have other arguments to make as well. That's just one of the arguments.
Okay, I'm just kind of trying to figure out.
I do.
I understand you're asking you're entitled to a hearing.
Yeah, I'm just saying, yeah, we could get evidence hearing at the court. It's either or. And Mr. Myers would like one, but I don't, what I'm saying is.
Testify.
No.
Evelyn, you might have just popped in, but this is only supposed to be the new charges, the 3 new charges. So Parvin is he's the actual attorney on that right now.
Don't just let Mr. Parvin talk. You can't.
I'm just saying, I'm not requiring the court to call the same testimony that's already been in the record that we're not disputing.
Test foot, not yet.
Right.
There's no way that that Parvin will be on the case if this goes to trial. If Lane's in custody, I don't see him letting go of the 180 days because it's the only leverage that he has, right? So, that's basically what they're playing with. They know that there's no case here, but they're doing this maliciously and intentionally anyway. All of them. The alleged victim and her spouse, the prosecutor all the way up to Conover, and all of the Tucson prefects are involved as well.
I just want to see if I can find it here while we're talking.
But the court agrees that the court could review it again based on the change of courts. I just want to clarify that we could get that.
Yeah, I'll talk about that. But appearance order with release conditions it's a form that, let's see what was dated. March 14th, which I assume was the date of the arraignment. So okay, well, because I think that goes back, Mr. Parvin, to under the rule 7.4C. If a motion alleges the existence of material facts not previously presented to the court, or the defendant is unable to, it's not previously presented to the court. What you're arguing is to get a new hearing, you have to show that there are material facts that were not previously presented.
No, it's an or. Okay, no, that's right. Let me talk. It's actually, as I mentioned, it's an or. As in, we disagree with that judge's decision, so we could special action. But I read the rules. We don't need to. We're alleging new facts, and we'll get into that. But I'm saying just before we even get to the new facts, it's a 2-part statute. It says if you transfer courts, you automatically get the hearing, even to get a different opinion from the newly assigned judge to make new findings of facts. Or if let's say this court rules today and doesn't agree with us, well, if we present additional facts, then even in the same court, we could request a hearing again with those additional facts. It's an or. So when you transfer courts, you get a rehearing just because you transfer courts.
But it says, hold on. It says, if the case is transferred to a different court, if the motion alleges the existence of material facts not previously presented.
Comma.
So typically, Mr. Parvin, as you know, we hear these all the time, and the argument is the defendant has a place to live, or the bond's excessive, or he wants to go to drug court, or some type of drug treatment. There's usually some allegation that a new fact has arisen.
In the case law, it says it.
All right, Mr. Myers, I just want to hear from Mr. Parvin, okay?
Yeah, because this is unusual. That's when there actually is a bail and release conditions already about a question of what they should be. In this case, we're disputing whether Mr. Myers was bail eligible to begin with. We think he should have been. So that's why we're taking advantage of the first part of the rule that we would get a rehearing similar to an appeal, although not really because this court is not an appellate capacity, just a different court.
It's a rehearing.
A rehearing, and that's why I'm making the same arguments that I don't think were fully addressed by the prior tribunal on when the release conditions became official. And again, Mr. Myers now tells me that he didn't get that pay. I didn't know, there was, again, we had to work so fast, but that would be an additional fact alleged that he'd like to testify about as of whether he actually did receive that paper that day or not. I could tell the court, I immediately, before he talked about Monday morning about it, I got the manager insurance that, this is official. That I could tell the court that we did have a conversation on that Monday. It might not have been Monday morning, but it was on Monday about it.
Okay.
But as far as Friday night, Friday it was heated, and we kind of just, or at least I did, took a break from the case for a couple of days.
No, I
And
didn't
that's-
block
that
anybody.
makes sense, Your Honor. And then the order came, for the Monday. But again, I have other arguments too. This is just
You
one
want
of
a
the
hearing.
reasons.
You want a hearing, right?
Right.
Yes.
We just want a hearing on the issue.
All right. Ms. Stiles, we typically grant a new hearing on reviewing of conditions. We do that all the time.
Not in these cases, Your Honor.
So what's the difference between a lower,
This dirty cunt.
a judge at the beginning of the process granting, setting bail as $10,000, and then they come up and say, well, he's got a place to live, he can live with his mom, blah, blah, blah. Please reduce that to $500 or whatever. How's that different than this?
Because then you're talking about offenses that are eligible for bail as a matter of right. This one is not. This one,
When you make YouTube videos, you forfeit your right. When you make fun of public officials, no rights.
based on the Constitution in Arizona, is not eligible for bail. And that's been built into the rules. So you have the Constitution, which is the Article 2, Section 22, that says it's not eligible for bail. And then you have the rule that also...
And it's not eligible because he was on release and then committed a new offense. And
Jane, no, he's not employed. He's in jail. He's been in jail for like 30 days. 33, I think.
allegedly. But when I think it was Judge Miller did the bond hearing, correct?
Correct.
When she heard that, was the question only
Condescending, pretentious, elitist, arrogant, and dumb.
Was he charged in the new offense, or you have to put on evidence that he committed the new offense?
So, Your Honor, we did everything in the case. So when the state
Even Parvin's job.
alleges that somebody has committed a new felony while on felony release and is seeking to hold them without bond, the state is required to put on the evidence and have the hearing to show that proof evident presumption great that they committed a new felony offense while on felony release. And that happened in this case. So the documents that the judge was...
So the detective testified at that hearing.
Correct.
And did kind of a summary like you do before grand jury.
Yeah, so the detective came in and testified, and we had the exhibits. So in this case, there were videos, and so those were presented to the court. The defense had the opportunity to cross-examine the detective, and that occurred. Mr. Myers had the opportunity to testify if he wanted to, and so he was advised that he had the right to testify if he wanted to, and he chose not to. And that was all done. And then we had certified copies to show that Mr. Myers was on felony release at the time, and so those were also considered by the court. And as the court just noted, it was the March 14th date. So Mr. Myers was present for his arraignment when the release conditions were set. They were done both orally, where the court advised him of his release conditions, and that was a pretty lengthy process of the court addressing that. And then he also had it was all ordered as well in the documents. So that all took place, as well as the testimony, and the court on the no bond hearing, after hearing all of the evidence, made the determination that the state met the standard of proof evident presumption great and found that he was on felony release at the time. And so he was held without bond. So the defense is arguing that he's entitled to this reexamination, but that's not what the rule says. It says may. But what that rule also says is that under it talks about that the court must hold him when that standard is met. And so...
And Rachel wants 33 years. That's what's going on here.
He is not entitled to just keep coming back because he doesn't like what the judge previously determined. There's nothing that would warrant this case revisiting that issue when the hearing has already been held on that. It's not like he waived it before or something. We actually had the full hearing on it.
Okay.
And may I respond?
Yeah, hold, just a minute. Before I do that, I want to pull up the indictment on the new case, just so I have the dates clear in my mind. Hold on just a minute.
Just a big time suck right here, just wasting time. Irrelevant, pointless information to waste time. Why read the rules? We're not going to follow them anyway.
So, Mr. Parvin, again, the arraignment on the new case was
pretty much Randy.
April 4th.
That was the new case, yeah.
Yeah, March 14th.
Well, that was the first one was March 14th.
The new one was April 4th.
Oh, I'm sorry.
Lane's right again.
All right. So in the first case, the arraignment was on March 14th, and there is a order in the file of the judge who signed that release conditions. He's on pretrial release. You're saying that order and that hearing wasn't. I don't know really what your argument is, because there is a court order in the file of that date.
But the minute entry with the stamp with the clerk was
Yeah.
not
Well, this
official
has a
until
I mean,
Monday the 17th.
I just don't. This is also stamped the 14th by the
Irrelevant.
Hold on. Let's hear Mr. Parvin. Hold on. So, Mr. Parvin, just mechanically, the way it works is arraignment was held on the 14th. Release conditions were set in open court, and the judge signed an order which was filed on the 14th.
But it wasn't. Well, there was something.
The minute entry is only recording what the judge said. This is an actual order that's actually in the file.
And I guess the question was, Mr. Myers, like it was paper saying, I don't know if might have been aware of it, was not aware of it. So when the minute entry came and acknowledging it, that was the argument that was not properly, at least, the law was attempted to be addressed, but I don't think it was properly addressed on the question of, was there proof evidence of that, Mr. Myers' knowledge of it. There's also a constitutional issue.
But let me just, he was advised of that during the hearing. I mean, you haven't provided me with the transcript, but I'm just assuming, and I think, Ms. Stiles, you were present at that arraignment?
Yes.
It seems to me that the judge in that case did address that he was given a release as to the indictment, and there's an order. So, I mean, he was on notice of this. I mean, it was told him in open court.
Again, the argument is a cooling off period of what, like, for example, I brought up the domestic violence. Technically, if you're convicted even of a misdemeanor, the judge says you now have lost your gun rights. I find you guilty. You need to turn your guns or you'll be a prohibited possessor. But there is, like, I think it's 24 hours, a period before it becomes official to give you time to process. And that's why I'm bringing up the 17th. By then it was official, and the conduct stopped. That's what I'm saying. Once we had a conversation on Monday, after, I guess that made, it ran late on Friday. I was tired. Mr. Myers, I'm sure, was tired. Well, I was even more tired, I think, because I didn't want to be on this case till Monday, as nor should I have, because nothing should have needed to be done that time. But then I immediately talked to Mr. Myers. I don't know when on Monday, but it happened on Monday, and discussed this minute entry that came in, and then I found out some stuff was happening.
So, for example, this order says, do not go to the victim's residence. And let's just assume, for sake of argument, so this was Friday the 14th. Let's assume, just for sake of argument, I'm not saying this happened, that Mr. Myers then contacted the victim on Saturday morning. Are you saying that wouldn't be a new offense while he was on release and be held without bond? I just don't. I mean, to me,
Well,
he's for trial, and he's out in the community, but with the restriction he can't commit any new offenses. And he commits a new offense just driving home that night. Let's say it was a DUI case.
Yeah, I'd be out on bond if I got a DUI.
No, not necessarily in that case.
If I could assault somebody, I could be out on bond.
Let me explain that.
Okay.
So, yes, I mean, in the sense that if there were a direct crime constitutional arguments, what the trial would be, legitimately believed he had a right to defend himself and talk about that he believes the charge unfair. He didn't believe he's committing any felonies, and He strongly believes that, and that's going to be a problem for this jury about defining the statute, as we've already discussed. But it wasn't going out there and committing a DUI or contacting the victim directly, something obvious. And then what happened was the release conditions were a little tricky to understand. There was a lot of debate. It was very heated on Friday. I'm trying to see exactly what you're getting. Remember, you get a piece of paper. We knew not to contact the victim directly. But there was discussion. I know you didn't. There was some question about what was and was not permitted.
They charged me because they said I violated the injunction. That's not a felony.
I'm going to try to explain. So
Mr. Myers, don't talk.
The problem was the cooling off period ended on Monday. It was a weekend. Now, in your example, if the next business day, if this were a Thursday, then Friday would have been discussed. The minute you've been in, and then have been official. So the only reason there was a couple of days is it was a weekend, and on Monday is when this was addressed. And as I made in the argument before, the conduct stopped, which means that proves Mr. Myers was aware this was official and stopped doing what he was doing at that point.
Let me ask this, Mr. Parvin. So the standard release conditions on his March 14th order says violate no federal, state, or local law. So that's in the
which he didn't.
That's in the statement of conditions of release. The minute entry would not have said that itself. The minute entry only says he's granted release with these conditions. It doesn't go through the standard condition. He's alleged that he violated a standard condition, that he violated no state law.
Okay, and I still think the better argument was that it was official Monday, or at least a good argument. Now I'm starting to think the better was the other way around, is we'd also...
And an even better argument is just following the rules. Let's just follow the rules. But instead, let's waste all kinds of time. Metcalf, let's waste all kinds of time.
I'd like to address, because it did transfer courts, I want to again say there's a comma. There are three, it's not one sentence, it's three specific scenarios. We also would like a chance to argue at a rehearing of why there was not proof evident of these last two felonies. It's not just about it. I mean, I thought at the time, and I still believe I was correct in thinking that, given the situation on short notice, the best argument to focus more on was that a pretrial release was not official. Now that I've looked into the evidence more, I'm realizing, the better argument is that no felony even occurred, and he's entitled to a rehearing that as well. As the court acknowledges, people make that request all the time. Why is this any different? I also made a constitutional argument, if you look at my reply, is yes, the Supreme Court, they can't really indicate Bricknell or whatever, there was a Supreme Court decision saying that upholding the denial of bail, saying it wasn't unconstitutional statute on the whole. But what it didn't say, it was that each individual couldn't come in and make a constitutional challenge. So that's why we want a hearing as well. And I would bring up the problems at the jail where he's deprived of the law library, the monitoring app. This is a very unique situation. Mr. Myers needs people to help because advice on challenging the statute, it's different than any other crime.
Let's have a hearing.
Hold on,
to talk about
Mr. Myers, I'm getting there. There's a lot of arguments I raised in addition to this first one. I just want to address all arguments. The other thing that I'd like to address at the rehearing is the facts now is, and I'm going to talk to Mr. Myers about it. This court is a lower court. The court feels it's bound by the Brown despite the change in statutes, and I understand the court's side as a reasoning believes that's still binding law, and it's our duty to then go to them and get how the Court of Appeals changes. Mm-hmm. But I hope the court at least, and I think the court does, because you're asking questions of everyone, understands the dilemma here. Part of the argument I'm going to make for bail here is this situation is much better decided before trial on a special action rather than hashing this out on what is going to be the messiest of trials. And we have again, I'm going to request jury instructions. The state's going to object. I have no idea what the court's going to allow or not at that point. If the court grants release conditions, and it can be extremely stringent, and I'm going to make that argument a constitutional argument, what we can do then, we can postpone this trial, and we can then out of custody, so Mr. Myers is not prejudiced, special action, the court's decision, and let's see what the Court of Appeals thinks. They can revisit their own decision on this new statute. That's fair. Well, I'll tell you what would not be fair, Your Honor, is for the court to say we have to go to trial under this, what we believe be unconstitutional, and it may be. We don't know how the next court's going to rule. And now he sits in prison or sits in jail while it takes me 60, 90, maybe 120 days to get an appeal done. I'm going to get help. There's already organizations contacting me. They want to be part of this appeal based on the First Amendment issue. And I need time. I need a couple months, a few months even. This is going to be it's going to be an epic published appeal, Your Honor. I think the court believes that to be the case as well. And Mr. Myers should not be in jail or in prison or in custody battling out whether this statute is unconstitutional. And I'll be making that argument after a hearing, but I'm just saying all the reasons why I'm going to bring up that there is a second part of what the court believes is fairness on constitutional grounds of granting bail based on facts. And that's what we're saying. Now, if the court...
Let me, hold on. So, Judge Miller looked at the evidence that the state had presented as to the new charges. And what I don't hear you saying is that that's going to change. So it would, hold on, it would just me being the second guessing Judge Miller, which to me doesn't, I don't think what the statutes or the rules directed at.
It says you can have a new evidentiary hearing.
Hold on, new facts, something that wasn't already considered. You see what I mean? I don't want to check her work basically, because I'm not an appellate judge.
And I understand.
You're talking in circles,
Mr.
man.
Myers, no.
Can I speak, please?
No, I want to hear from Mr. Parvin.
Why can't I speak?
Because it's his motion that's as to the new case. And I want to hear from him. This is a very technical point.
I know, and it's just talking in circles. It says you have. It says if it's transferred to a new court, you can get a hearing, and the court can order a new evidentiary hearing, and you can find proof evident or not. It's clear. It's black and white.
I'm reading the rule different than you are. Go ahead, Mr. Parvin.
Well, instead, let's read the actual rule. He reads the rule a little differently, but is he actually reading the rule? No, of course not.
Yes, and that's an interesting point. I think it's similar to having how you have 12-person jury. People might have different opinions on the evidence. And I think we were in a rush there because we had to have the bond hearing immediately. And yes, Judge Miller did find proof evident based on what she interpreted the statute to be. I would hope this court might have a different interpretation of what knowingly means. And this is my concern of the statute in general. I don't know what Judge Miller's definition of that statute was. I don't. It's too hard to figure out. I don't know what this court's definition of what knowingly acts. For all I know, Judge Miller might have agreed with my interpretation of how the statute reads that you're guilty even if you knowingly act. Sounds like this court disagrees and thinks it will give me a jury instruction, but I don't know. I don't know what Judge Miller thought. That's a problem. We'd have to have a hearing on the evidence there. I'm not saying you need to overrule Judge Miller. I'm saying maybe there would be a different opinion on the facts. But really, what I'm saying, I'm focusing now more on this. That's why I like the conversation. So many things come up is the big issue is we need to get to appeal on this issue. And I think the court agrees. So I appreciate the court not wanting to overrule Brown because they're not sure. But Mr. Myers should not be in custody while that's battled out. We should be given a chance constitutional on this argument. We've made a very powerful case. I think the court acknowledges we've made a powerful argument. This should be fought out on a special action, and I think the Court of Appeals definitely will take this one, Your Honor, as a first impression. This issue, and he makes any videos. He so much as just goes on social media whatsoever, does anything. Back in there he goes. I think that'd be fair.
Ms. Stiles, Mr. Myers being in jail, preventing him from filing a special action, as we all know. If the Court of Appeals takes the losing party can file a petition for review, it's a long process that he would sit in jail while this First Amendment issue is being hashed out.
Your Honor, Mr. Myers made a choice. He was out on release on the first case. He was released to pretrial services. He was out and he could have litigated. But what he did is he goes home, and then within that weekend, he goes and he does the same conduct again. He keeps doing it. So he doesn't get to just keep violating the law while he's on release and get to be out in the community. That's what this law is designed to do. Is the Constitution has, if you commit a new felony while state, in order to be able to prove that, the state put on the evidence. It's the same evidence that would be presented if the court kept having the hearing over and over again. It's the exact same evidence. What the defense is asking for is just for this court to basically just review Judge Miller's work and then say whether they agree with her or not, and that's not appropriate.
Is it your position that there's no wiggle room at all if you commit an offense and the state can They must hold them. They even say, "Hey, I believe."
Does anybody know if the feed was like this on Prophet's channel? Was it choppy towards the end?
The state's case, but I think that there are release conditions that could protect the community. Even if the judge finds that, are you saying that the judge could not release a person no matter what?
Correct.
No.
So that's under the Arizona Constitution that states that. And then even under Rule 7.
Oh, now she's super familiar with the Constitution. This dirty bitch.
Or in talking about the procedure, it talks about if the court to deny bail, the court must order the defendant held without bail until further order. It doesn't give a discretion. It's a must.
Not forever.
Calm down. I'm gonna have an opportunity to speak
How could there
next.
be a further
Calm
order?
down. I have an opportunity to speak next.
Mr. Myers, just let her talk. She's just citing to a statute, okay? Just a rule.
So why don't we just go to sentencing?
No, calm down. That's not. We're gonna get some concessions.
We're working through this issue, so just let her talk.
And then, Your Honor, under Rule 7.2, under right to release, when you go under B, it talks about before conviction, defendants charged with an offense not eligible for bail. And so it talks about under B1, it says not eligible based on commission of a specified felony or any felony while on pretrial release.
What rule are you reading from?
So this is Rule 7.2, and this is under B, and I was reading from B1.
Okay, hold on, let me get there. B1, okay.
It says, and then it says a defendant must not be released if the court finds the proof is evident or the presumption great that the defendant committed. And under B, any felony offense while the defendant was on pretrial release for a separate felony charge.
Okay.
So there's no discretion. It is the law requires that he be held without.
So must is required. Okay.
Yes.
Yeah, Mr. Parvin. Mr. Myers, just let Mr. Parvin argue. We're just talking about what the meaning of the words of these rules are.
So, hold on. No, I know we're going to get there. So, the state's not correct. So the state is correct on the statute. Here's the problem, though, and I think the court's picking up on this, is there are different interpretations of what knowingly means. What we don't know, and I don't know, I didn't ask her. I don't know, and I didn't get to request jury instructions for a bond hearing. I don't know if Judge Miller thought that my interpretation is correct, because I believe, if you ask me, you can get mad at me, other people listening get mad at me all want. I think the statute says you're guilty just because you knowingly acted. I may think the statute's unconstitutional, but if I were on a jury, I would still find guilty because I have to follow the law. That's my interpretation of this statute. I would find guilty, even if I didn't want to. I'm not going to use jury nullification. All right? I know you would. I'm explaining my interpretation of the statute, how I would still find guilt here. I may not like it. I wouldn't want to. Now, it sounds like, and that's great, that the court may have a different opinion than me and think that the statute does give knowingly on both counts. Maybe this court would, find differently. But here's the problem. I don't know what interpretation Judge Miller used. Did she use the one I believe, that he's guilty? Or did he use the one that your court believes the statute says, which permits, all the evidence?
Das Foot. You're not Das Foot. I probably wouldn't have said that, but it's true, right? I mean, that's what she's trying to position it, to have the jury instructions be that you can't even bring up these constitutional arguments. I mean, we all see the writing on the wall there, right? So, I mean, he had made the point earlier in the hearing pretty clear, but I guess he wanted to not be unambiguous at all on that. Everybody does, Sassy. Nobody out in the real, like, for some reason, I've got the people that enjoy my stories, right? And then there's the haters, and then there's Pima County government that is completely and totally dialed in to everything going on my channel because they're insane. They're insane people. Let's make a prediction. I bet 2,500 people see this video, we'll say in the next week. So truly, an insignificant amount of people. Jane, that's the smartest thing I've ever seen you say. Ever. Ever. So, I mean, yeah. You get what I'm saying about, like, just do the right thing, and then all the people on the internet that stand up or here pretend to stand up for the First Amendment, there'd be zero attention on your city if you didn't do stuff exactly like you're doing to Lane Myers. I mean, that's the reason the story is getting covered, right? Because this is so gross and insane and criminal. And it seems like the court is in lockstep with the prosecution. So, yeah, the people that care about these things are really interested in what's going on out there. These people are demented.
Knowingly. I don't know. That's why we need another rehearing, because I'm not even sure which standard I'm allowed to argue now. I'm confused, to be honest. I am. That's why I filed the motion to dismiss. So at the rehearing, we could discuss what standard the court's going to use for the statute and really determine, was there proof evident of these two offenses? Because really, one was just showing public information about explaining why this was easily accessible. The other was showing defending himself, an injunction of why he's appealing, explaining law. And again, that's all I'm asking on that end. We get a rehearing because the court may have a different interpretation of what the statute means. And again, this is not something I had time to come up with because I've had to research the statute. I'm just telling how I believe. Sadly, I think it means he's guilty under the statute. If I were the jury, that's how I would read it. But again, I'd hope other jurors don't find differently. But now the other point, and this is more a point I'm trying to explain to Mr. Myers here, is we have a real problem on special action. I think everybody agrees that the Court of Appeals needs to look at this issue under the new statute. And I was really hoping this court could disregard Brown and say, this new statute, I can be the first to act. I think the court is making a well-informed decision, believing that it's not my job to do so. That needs to be the next court. All we are asking, if that's the court's ruling, and it's a good ruling, judge, permit us out of custody to special action and give Mr. Myers full knowledge. The only thing Mr. Myers will be allowed to do with the computer is to help in his defense on the appeal so we can talk about it. There will be no more posting of social media. You can make the most stringent conditions. I think I even mentioned potential house arrest, although he needs to be able to go, grocery shopping and other things. That case I've cited, the state cited Arizona Supreme Court case that upheld this. Again, it didn't say that the court could never find a constitutional issue where release would be appropriate.
I'm with you on that, Vicky.
All it said was the statute as a whole is valid. Similar to the state's argument, the state argued that Mr. Myers doesn't have standing and that the statute itself is valid. I disagree. I think he does have standing, but that was what the Supreme Court was saying, is that.
Hey, Jane. I think I remember reading that in a comment, I don't know, a long time ago. Jane, I read every one of your comments. I'm obsessed. But you never actually really even understood Foshin. It was a miss, I thought, over all this time.
on its whole, it's valid. But then it went on a case-by-case situation. Each individual judge can review the constitutionality as applied to a defendant. And I think the court agrees in this one exceptional case, because we need to go to appeal here. There should not be a trial before this is solved, Your Honor. Release conditions constitutionally, and you could cite the Arizona Supreme Court in your ruling of why you're doing it, that you're finding in this case only, it's constitutional to grant Mr. Myers release, again, maybe on house arrest with permission to go to grocery shopping, just, to leave it to state's concerns. And, if this appeal takes, 120 days, a few months, maybe if Mr. Myers is doing well on house arrest for, 90 days of that, then I can file a motion to modify and be continuing off house arrest if while the appeal is pending. I'm just offering one step at a time.
So let me interrupt you real quick.
Okay.
Well, I would like to do some more research on this issue of whether committing offense while on release can never be bail eligible. What if we came back later in the week to continue this argument after I've had a chance to read some of these cases?
Your Honor, I start a trial tomorrow that goes for 2 weeks.
Murder trial. Murder trial. Got our priorities real mixed up.
But that's not really fair to Mr. Myers, Your Honor, to wait 2 weeks.
Well, this.
But let's have a conversation for another 22 minutes, and at the end of that, decide on, 2 weeks is okay.
And Your Honor, what I'd point out is that the defense has presented zero case law that says that he is eligible.
So, like, you just heard Lane. They don't need to present any case law because it's the rules.
Or bond following that finding, the proof evident presumption great. They have cited zero case law.
Until further order. You're getting your on.
What they're referencing is a rule that says may. There is no must. What I'm referencing are the rules that say it is must. And it is an offense that is not bailable. Okay. And so they keep talking about offenses that are bailable as a matter of right. This isn't a different category, right. And it's in the Constitution, it's in the rules.
Here's what I'm going to do. I'm going to.
The Arizona Supreme Court gave you permission if you find a constitutional issue to grant release. That's what I'm saying.
Mr. Myers, hold on.
Please let me say something.
What do you want to tell? Okay, go ahead.
7.2, she just read it. It says until further order. And then 7.4 defines the conditions that allow the judge to make that further order. 7.43, transfer to a new court, new facts, or money. That's the conditions that allow you to make that further order. It's not statute and case law. It's literally the rules of procedure.
Okay.
7.2, you find proof evident must be held until further order. Well, how could there be a further order? Oh, let's go to 7.4, which is the definitions of what, there's only 3 ways there can be a further order. A transfer to a new court, new facts, or the money is too high. Those are the reasons that you can get a new order. We're obfuscating, right. We're beating around, we're talking in circles.
Mr. Myers, I'd explain why.
It literally says until further order.
Myers,
and then it says, here's how you can do that.
I think it's understood.
Right.
I don't understand the and the Mr. Myers. What I should have heard is pause from everyone. Right? And maybe let's revisit the rule and let's find out if maybe Mr. Myers is exactly right. Right? Instead, we'll just gloss over what the madman said because he's a madman.
I'm going to do. I'm going to.
The Arizona Supreme Court gave you permission if you find a constitutional issue to grant release. That's what I'm saying.
Mr. Myers, hold on.
Please let me say something.
What do you want to tell? Okay, go ahead.
7.2, she just read it.
You can hear the frustration in Metcalf's voice. But there's no humility. There's no humility after he's done. There's no just. These people are morons.
says until further order. And then 7.4 defines the conditions that allow the judge to make that further order. 7.43, transfer to a new court, new facts, or money. That's the conditions that allow you to make that further order. It's not statute and case law. It's
Yeah, just like the dabbler, he can't keep up. They decided to bring the court reporter into the courtroom instead of just having it recorded, right? To have Mr. Myers slow down.
literally the rules of procedure.
Okay.
7.2, you find proof evident until, must be held until further order. Well, how could there be a further order? Oh, let's go to 7.3, or excuse me, 7.4, which is the definitions of what, there's only 3 ways there can be a further order. A transfer to a new court, new facts, or the money is too high. Those are the reasons that you can get a new order. We're obfuscating,
right.
we're beating around, we're talking in circles.
Mr. Myers, I'd explain why.
It literally says until further
Mr.
order.
Myers,
and then it says, here's how you can do that.
I think it's understood.
Right.
I'm just saying, read the Arizona Supreme Court decision,
Okay.
where you
Here's what I'm gonna do.
find an individual constitutional basis to release them based on this huge appeal we need to do.
I'm going to take this matter under advisement and read those cases. And if I believe that we need to set another hearing on bail eligibility, I'll have my JA reach out to counsel, and we will get it scheduled at some point. But I want to read I don't want to rule against you, Mr. Parvin, right now, because I want to read those cases. I would prefer to just set a hearing, continue this on Friday.
Please.
But hold on. But this will give me a chance to review everything. That if I think that we need a hearing, we'll find a time that works.
Friday does not work for me. It's the only day that does not work for me.
Yeah. So, Ms. Stiles is starting a trial. We'll have to find a day that works. But I want to read all this first. There's a lot of paper in this case, and I think I got through it all, but I didn't get the depth on this that maybe I think I can get by reading this stuff more closely.
May I ask one last thing?
Sure.
I just want to end. First of all, I think I've explained why I don't know what how the trier fact is going to treat that. I don't know if Judge Miller agreed with my interpretation or perhaps yours. You haven't exact, nor should you say your interpretation.
Right.
But I'm just saying that'd be something I would need to know if arguing, for proof evident. That's a real problem. Well, I don't think we got a fair hearing.
Right.
Now, the biggest concern, I really believe, if you review the Arizona Supreme Court decision, the state cited it. It was, where is it? Moreno versus Brickner.
That's in their response?
Yes, that's the one approving the statute. And what it left open was the opportunity for a court to find an individual constitutional basis as applied challenge.
Okay.
So what I'm saying, in addition to all the arguments I've made, so why I think we should get a rehearing based on whatever this court's interpretation of knowing is. It may be different than mine. I hope it is. But the biggest argument for release is so we can appeal out of custody and do this the right way, Your Honor, rather than rushing a very messy trial. And the Arizona Supreme Court has given you the discretion to find a constitutional reason to grant it as only applied to Mr. Myers, as in you would not be able to let anybody else out. But you'd be able to let Mr. Myers out because he has this appeal, which, as the court, I think, agrees, needs to be heard fast.
Got it. Okay.
How can I be guilty?
Hold on, Mr. Myers. We've made the argument. We've made the argument, Mr. Myers.
All right. So then.
What about this pretrial stuff?
The last. That's a good question, Mr. Myers. So Judge McDonald set a trial in July on the new case, correct?
So, Your Honor, he did not.
Oh.
He
And
did. July. On this case, he did because I agreed to it.
July
Mr. Myers
21st.
agreed to his.
All right, so just to be clear, now we've moved on to the pretrial stuff, which was the point of the prior hearing that got rescheduled to this hearing date. So this should have been the very first thing that was addressed, because this was the original purpose of the hearing.
Yeah, on the new case.
So we were trying to get the trial set, and then there were all these objections to trial being set. And so I don't think anything's happened.
Okay.
Rachel apparently bumped her head and forgot that they set the trial. But we're supposed to take her seriously.
I saw a minute entry though.
Said July 21st.
Hold on.
Literally said July 21st, and then he said we could always move it up.
Okay, hold on. So in the hearing on the 15th,
He said he was postponing the one that I'm the lawyer because I had some pretrial issues I wanted to talk about first, and he said in that one.
the minute entry isn't clear, but I think the intent was that the
So the cases have not been enjoined yet, but we're back to pre-trial stuff on the first case, so any shushing now would be inappropriate. If it was shushing in deference to Parvin. But I think the last shush was actually shushing in deference to Rachel. Let's see if we can hear that.
Oh,
And
He did. July.
On this case, he did because I agreed to it.
July
Mr. Myers
21st.
did. But okay, what's on?
yeah, on the new case.
so we were trying to get the trial set, and then there were all these objections to
Don't talk.
trial being set. And so I don't think anything's happened.
Said it.
Okay. I saw a minute entry though.
Said July 21st.
Hold on.
Literally said July 21st, and then he
okay.
said we could always move it up.
Okay, hold on. So in
Maybe that one.
the hearing on the 15th,
He has an opportunity to be heard.
He said he was postponing the one that I'm the lawyer because I had some pretrial issues I wanted to talk about first, and he said in that one.
the minute entry isn't clear, but I think the
It's
intent
clear.
was that the second case, we'll call the Parvin defense case,
Oh,
that
the
was set on the
intent.
21st. That's in the minute entry.
It was.
Your Honor, that's what we were trying to do. And we were trying to get the cases set for trial. And then Mr. Myers kept objecting to trial being set because he wanted trial set much sooner. He asked for in a week.
In my case.
And
Okay.
so that's how this got. But ideally, we're going to consolidate
It's all funny to Rachel.
the cases. But that's a different.
Mr. Mayor, just let her talk. She's giving her.
It's in circles.
But you have to let her talk, and then you get to talk. Go ahead.
So the reason why we're not taking up the motion to consolidate is because Mr. Meyer says two different things. One, he says he wants a bunch of different trials to take up the separate issues because he's said that there's going to be many, many trials of, with the different counts.
No.
Which
That's
sounds.
not-
No, just let her talk. Just let her talk.
but-
You'll get.
That was an aggressive. That was aggressive. Just trying to stop the big time suck. That's all we're trying to do here. Lane's just trying to stop the lies and the time suck from Rachel and the court. But I don't know how long we've been live, but we're 3 hours into this hearing, and I haven't heard word one about the legal resources.
Chance.
I know, but I want to clarify it because
You'll get
your
your
argument
time.
is incorrect. What I was saying
Myers.
is appeal, like a new trial, like post-conviction, remanded for new trial,
All right.
not different charges, new trial. That like we'll have the first trial, and then if it gets appealed and sent back for a new trial, we'll have a new trial.
Okay.
Not,
all right.
not severance.
So have you filed the motion to consolidate? Yes.
I have not, so we are dealing with an issue where we've got Mr. Myers is representing himself on one, Mr. Parvin on the other. And then the motion to consolidate is dealing with both those things. I want to make sure, one, that he understands what that all entails, a motion to consolidate.
I'm about to do
Is
that.
this
in 5
bitch
minutes.
serious?
All right. Hold on. Go ahead.
So that was the issue, is because I've heard different things coming from him, so I want to make sure he understands. Because sometimes the language he's using suggests that he's wanting a motion to sever counts, and then another thing says he's wanting to
Okay.
join them, and that's why there's some confusion there. And then also when we were in that hearing to set trial, then it was getting separated out, like, he wanted them separate and one needed to happen before the other. And so I think Judge McDonald, he was just coming in to set a trial, and then there were a lot more issues going on than he was necessarily prepared or informed to be able to deal with.
Okay. Let me ask Mr. Myers, in the second case, the newer case, are you going to ask to represent yourself?
Well, we wanted to see what happened with the motion today, right? Obviously, so our plan was hear this motion, right? Mr. Parvin filed a great motion. We're going to see what you rule, right? And then we got to have, put our heads together, like, okay, are we going to appeal? It's like, if you grant it, obviously the case, dismissed, whatever, right?
Right.
And so then it's like, we don't need to have a Feretta. We don't need to set a trial because there's no trial because the case got dismissed. And so that's kind of like why we were waiting, trying to get this settled as fast as possible, the motion for that, right? And then now so then it was like, well, what's that leave us? That leaves us with the remand, right? Which I please grant an extension on that one too.
On both cases, yes.
Yeah, and so then it's like, okay, what's our next strategy, right? Okay, do we want to do the remand or the special action? But based on this, we're going to do the special action. So it's like, okay, my thing is basically, once we get, I know you said that, right? Because I take what you say serious. You said, we're not going to go back and forth. He is my lawyer. He's not, you know what I mean? What I'm saying is obviously I can't do the special action from jail, right? So that's, we're hopefully going to address that. But, now that adds another thing in, like, okay, well, today, we were going to, if hopefully you get dismissed, then now it sounds like we're going to do special action, so I'm going to have to keep him on a little bit longer. But then it's like, okay, that'll continue the trial date, you know what I'm saying? I'm willing to waive the speedy for that, right? Now, if then he would still be on there, right? And then once we would have come back, the special action would get ruled on. It would either, granted, affirm, send back, you get what I'm saying? Then we'll be back in here, right? And then so it's like at that point, then once he runs with the special action, then it's like, okay, well, what else is there to do? That's when I would take over, because you get what I'm trying to say is, I'm going to be the one that questions Shannon Walker under oath. I'm not giving that right up under any circumstance. So I've been waiting for that my whole life. And so that's going to happen. And so that's why I want them consolidated under 13.3C for judicial efficiency and interest of justice. And Rachel said at the couple of hearings ago when you were here, oh yeah, we want to do a consolidate. And I said I would stipulate to that. And then I heard it with my own ears. Last hearing with the Judge McDonald, the judge asked her, will you please do a motion to consolidate to help the court do, resources scheduling? And she said no. That was before the hearing. That was off the record 7 minutes before the hearing started. So for her to come in, this is what I'm saying, she talks in circles. Then she said, well, no, I didn't say nothing about sever. I said if I don't get the right to represent myself, then it's going to be a new trial for failure to ineffective, remanded back. That when I said get through the first trial, it's so that if post-trial, post-conviction sends it back for a new trial, or there's an order under 20 or whatever the rule, for new trial, by you, that you get what I'm saying. When I said a new trial, I didn't mean sever. No, I mean, I want them all in one, consolidated, but I don't know how that affects him being, doing the special action.
May I say something?
So it seems to me that I don't want to set a trial date today where we have two separate trials, because it may be that everyone wants them consolidated. You want Mr. Parvin to continue to represent you to do an appeal.
For the special action, right.
So maybe if we set the pretrial conference out for a while, and then maybe this you'll get to a point where you.
But there is a July 21st already, right?
There is. It's on the calendar.
That's what I'm saying. So that's why, because that's what I brought up. I said, well, how can it's hard to, under Rule 8, you can't just, you got to have extenuating. You get what I'm saying. Under Rule 8, you can't just be like, all right, we're gonna check.
May I say something?
But he said that it can be brought sooner without violating.
I'm
Rule
going to
8.
clarify the situation.
All right.
Your Honor, I can tell you my forte is motions and appeals. I enjoy doing it. I'm proud of my motions. I think it's going to be a great motion for appeal, and that's what I'm focused on. I think that's the heart of this issue. Mr. Myers informed me that in the event we can't do motions, he wants to do the jury trial himself, and he has every right. He's also does some training, paralegal training. He knows he's done trials himself. He's competent. He wants to do this if need be. I don't want really a speedy trial. Mr. Myers does. Hold on. I'm not explaining. I want to focus on this. This needs to be handled by the Court of Appeals and the Arizona Supreme Court. But obviously, free for all. I have no idea what's going to happen. Appeals in the Arizona Supreme Court. But obviously, free for all. I have no idea what's going to happen. But what do we have to lose? That's why the argument is, if Mr. Myers wants me on this case, if this court wants me to remain on this case,
Yes.
grant the constitutional basis I gave you for release conditions, and we appeal out of custody. And again, offer the most stringent conditions possible and warn Mr. Myers that if you mess up even one time, you're back in there pending the whole appeal. And that's the way I'm on the case. We'll do this without a mess at trial, without all these things you've heard. That's the fair thing to do, Your Honor. I will end with that. But again, I just,
Can
if that makes sense.
Can I add something to that? I wanted to say that the reason I want a fast and speedy trial is because I'm sitting in jail with no bond.
Right.
You know what I'm saying? So if I'm out on bond, we can take 2 years. You know what I mean? And she can have her little settlements and all this kind of stuff.
And the appeals court can get it right then.
Okay.
But if I'm sitting in jail with no bond, I want it as fast as possible.
Understood. So let's reset this. How about
I hope Rachel heard that and gets it. Rachel's email is in the description. Reach out to her. Ask her. Reach out to Rachel and ask her.
when is your trial over, or when would you have time during your trial? What's like the dark day for whoever's trying your case?
So his dark days are Mondays.
Okay, so
next Monday.
Next month.
How about we could do like Monday, May 19th? Monday, May 12th, I have a lot on.
What?
And I know for some reason I have a trial set on that day. I don't know why. It's must be someone else's case. But the 19th.
So I have, just to be clear, so it's this week and next week that I'm in trial. After that, I'd be open to other dates as well. So it doesn't have to
That
be.
hampers me from filing like the remand and stuff because that's going to exclude. Like,
Well, we're clarifying. You might again.
I can put all that stuff.
We'll
on.
get a ruling on whether the court's going to consider my argument of why I can special action out of custody with Mr. Myers.
Yes.
Okay, because
That's
we
what
don't want to
you're
wait till May
saying
19th for that. I got to get started on that.
Right.
You're saying the bond hearing will be May 19th or the
No.
pre-trial?
In the event.
We're just gonna have a pretrial conference
Oh,
to
okay,
revisit
okay. I thought
these
you were saying-
issues about whether, including whether you get a new bond hearing. How about Monday, May 5th? Would that work? And
That would be fine.
how about with the victims? That work?
Yes.
To clarify, will that be, if the court agrees that I should get an opportunity to argue on whatever standard this knowingly means, either a hearing or if the court agrees.
Unreal. Absolutely unreal. I'll just push it out 2 weeks. No big deal.
Constitutionally, we should be able to appeal. Will that be addressed before that point or on that day?
I'm first of all, I'm going to do the research and try to come up with an answer with that. And on the 5th, we're going to talk about the status of the case,
Thanks,
whether
Becky.
to set
I
two
appreciate you
separate
guys.
trials, whether to have a bond hearing. I just going to have it kind of open-ended based on the way things go.
I guess Mr. Myers' concern is we do want a special action. I don't think there's any. I know there's 14 days to actually I think it's more to felony because there's more there's a time limit of when you can appeal a ruling. I know special action doesn't have a time limit, but they do consider the appellate time limits for when you need to start the special action. I'm just making a record that the court's giving the Court of Appeals basically a reason why I'm waiting, and that's my concern. Is
Yeah, I haven't ruled on the motion for bond hearing yet, which is wrapped up with your First Amendment issue.
Okay, so that would be, and if the court, let's say, well, okay, as mentioned about legal resource. Well, we'll get to legal resource. This is all part of it. Someone's bringing up about the legal resources.
I can't just sit in the jail and suck in my thumb right now. I
Hold
got
on.
some other things that we need to
I know,
address for
but we're
pre-trial
getting.
right
Listen,
now.
Mr. Myers, I think we made a powerful
We've run out
argument.
of time.
But
I'm hoping that the court has considered why you should be released pending this constitutional issue.
I agree with that, but
So Metcalf says, we ran out of time. Excuse me, I got dark chocolate caramel in my mouth. It was delicious. Metcalf says, well, we ran out of time. This is where the hearing started. This was the important issue of the day. Mr. Myers needs legal resources while he's preparing for his trial, right? The trial date didn't change. The trial date is still July 21st. So over the next 14 days, Mr. Myers can't do anything. He has no access to legal resources. Is somebody on another channel somewhere asserting that Mr. Myers has adequate access to legal resources? I'd like to visit their channel and see what kind of content they're sharing with the public, because that it's outrageous. Rachel continues to lie. Oh, I personally checked with the jail and they said that he has access to legal resources. Turns out that's not true, because he doesn't have access to legal resources, Rachel. Guys, I know it's really a bad week for her, but these are questions that need to get asked. And she won't return my emails, so maybe she'll return yours. Where is the access to the legal resources? Where is the witness list? Rachel, where are they?
Still need to work the case in the, my case
Okay,
as
we've run out of time, Mr. Myers.
Can you please do something about the disclosure? That's all I just want to, because this is supposed
Well,
to be.
let me set the hearing first. Monday, May 5th at 3 p.m. for 1 hour or an hour and a half. We'll just set it for an hour and a half.
Yeah.
That works for everybody?
Yes. And then that's going to be a determination of whether we get a rehearing or that will be the rehearing. That's what I'm trying to
Whether you
figure
get
out.
a rehearing and whether we set the cases for trial together or separately. I think we just need to address everything that we've raised today.
All right, but we could, in the court agrees with me, we might.
So we're going to address everything that we raised today in a 3-hour hearing, and we're going to pack it into an hour in 2 weeks after Mr. Myers has been even further and maliciously prejudiced in this case. Okay, cool story.
Lose a rehearing that day or discuss release conditions. I'm not saying the court has to, but if the
we can address
we don't
that.
want to do another 2 weeks after that, is what we're saying.
And Your Honor, it sounds like Mr. Myers has some issue with disclosure, so if we could try to address that I don't know what his issue is, that's why I want to.
So I'm going to do, in the first case, it'll be pretrial conference and status conference. In the second case, it'll be a status conference on May 5th. Okay, Mr. Myers, what's your disclosure
You have
issue?
their list, they submitted state's potential list.
No, I haven't looked at that.
Do you have it up there?
Is it filed or just filed with Sentinel?
Yeah,
I
so
haven't
it
looked
was
at that.
the state's notice of witnesses and
List of
exhibits.
potential witnesses and exhibits. It should be filed.
Okay,
it
hold
says.
on.
On the 15th.
Okay.
Late.
This is very important.
It was filed on April 15th?
That's what it says.
It's a good question, Sassy.
Oh, here we go. All right. Okay, I have it up.
All right, thank you. So 15.1B1, name, address, and any relevant written or recorded statement. This is boilerplate trash right here. This doesn't come anywhere near meeting the rules of disclosure. It says there, it doesn't even say their name, address, and any relevant recorded statements for the witnesses. And then it says under their their exhibits, any and all. And you've been around the block a long time, Your Honor. Anytime they start the statement with any and all, boilerplate trash. So here's the deal. Under 15.1B, 15.1B5, lists intend to use at trial. Any and all photographs. They talking about Metcalf's family photos. They talking about my baby photos. Or they talking about photographs. They need to list out all the photographs they had. Then they can say, we'll use any or all of these photographs that we have in this list. Then they're going to list, they need to list out the witness statements. And then when they could say, oh, we'll use this witness statement or not. But they need to say the witness statements that they have. The police reports they have. The statements they have. The YouTube videos they have. The property they have. The body-worn camera, any and all body-worn camera. How would I even know what body-worn camera they have if they don't list it?
All right, Mr. This is a very complicated issue, actually. We're going to address this.
This is all.
It's a complicated issue that we started the hearing with. It was very important to us at the very beginning of the hearing. It was critically important to us at the beginning of the hearing. So important that we delayed it to the end of the hearing. And it almost got forgotten completely, had not Never mind.
A reason why I think the court should grant our request to appeal out of custody, Your Honor, because this would all be moot when we do this appeal.
But I have a deadline to respond to them, and I have 4
that can be
days from now
extended.
to
That can be
respond.
extended.
Can you extend my rule? You know how I got to respond within 10 days of theirs? Well, I feel like I'm going to file a Brady motion in the next couple of days because I need this exculpatory evidence. Where's in number 8? Where's Shannon's loyalty oath? Why haven't you given it to me yet?
So that is not a motion that he has to respond to, so he
No,
doesn't have a
hold
time.
on. I have to file
Mr.
mine
Myers,
within
look,
10 days of them
when you,
filing theirs.
Mr. Myers, he may agree you get out next time based on this issue we can appeal.
I
Mr.
still
Myers.
have to work the case.
Hold on. We're going to address this on the 5th.
The
I can't.
15 stuff, the Rule 15 stuff.
Yeah, we can address the Rule 15 things on the 5th as well.
Because I need to.
We're running out of time, Mr. Myers.
Look,
it's a complicated issue.
It is.
I can't resolve it
I don't
today.
want you to get.
Mr. Myers,
I understand.
remember, if we get
Again, a complicated issue that we started the hearing with, and it seemed like the issue of the day. You would think that it's the issue of the day, right? He did say, I want to leave bond to the end. I want to leave the bond to the end. Let's take care of this. We got to make sure that Mr. Myers has access to legal resources, right? He's said it in every single hearing so far. Oh, we're going to court order these resources. Comes back the next hearing. Hey, I don't have legal resources. And Rachel says some bullshit like, oh, of course he does. And then we find out the law library doesn't exist. And then they say, okay, we're going to court order these legal resources. Okay, he goes back, comes back to the next hearing. I don't have access to legal resources. Rachel says, oh, it's on the tablet. It's on the tablet. But you still have to have access to that part of the tablet, right? The part that has the legal resources. And does he have permission to use that? No. No, he doesn't. Rachel just lies with impunity in open court. And she thinks that we're just going to be silent about it. I don't think so.
appeal out of custody, you don't have to worry about this.
And let me talk. Can you grant me an extension to file my Rule 15.2 B and C then? That's what I'm trying to say. I have to. I have 10 days to file mine when they filed it. So I have 10 days to respond to this with my list. And I'm saying that's 3 days from now. So what I'm saying is I either need an extension to file mine, or they could say, oh, you can't use any of that because you didn't file it in time.
So, Your Honor, the state's Rule 15 initial disclosure was sent out with the initial discovery. This is just the further, because he asked for a more specific list, and so we sent him a more
they sent him a more specific list with no names on it.
specific
This
list.
is not specific.
It's all the disclosure. We've sent him all the disclosure. He's already filed his 15-2, so he's not in violation.
Okay.
He sent me a 15-2, so he's not.
Beginning, and I'm going to amend
What
it.
I can say is he's not in violation of anything. If for some reason there's some deadline, we would agree to extend it. So he's not going to be in violation of anything.
It's 10 days from theirs.
And I need to join in that as well because I wasn't sure if he's going to represent himself or not at a trial. If there's going to be a trial, I have not filed the separate 15-2, but it would be joining Mr. Myers' 15-2.
So noted. All right, we'll
you're
see you
gonna
back
update
here
this?
on May 5th.
Well, we got to get through. Look,
Off
I
the
want to get through the
record.
appeal.
This should. I need their witness list.
And that's that. That's it. That's how it ended. I don't even know what to say. Alright. This is a public service. Reach out to Rachel. Reach out to her. What's here? We'll get some exit audio. How about that? You guys know.
Maybe I could get access to.
We're out here today to ensure our natural rights are respected by those who swore an oath to support, protect, and defend the rights of the people. The purpose of all interactions is to peacefully promote government accountability and transparency. Please like, share, and subscribe so this message can reach as many people as possible. I implore you to peacefully seek redress to any and all of your grievances. This is a public service.